Page number 1, item number 1 to 4. Page number 2, item number 5 and 6. Page number 6, item 7 and 8.
Item 7, the part of matter, last time already passed an order to be taken about 12. There is order, specific order, last order, 18-9 order. So noting is not there.
It is now avoidable when it comes. Let us see when the matter comes.
Page 7, item 9. Page 10, item 10.
No, Lord, item 10 is a part or matter. And written note of submissions, bullet point of arguments, and sequence-wise dates have already been filed by the appellant. And my long friend appearing for the respondent side, he has also filed the written note of arguments. On the last occasion, your lordship had directed to mention for upgrading the matter, but since the mining matter was being heard and Honorable Advocate General was appearing for the state, on that day it could not be taken up. So I pray my Lord to kindly take up this matter today. I will take maximum 5 to 10 minutes.
Let us see.
Sir.
Is not well issued board, and this is in the 226 criminal petition, there's CRLMP assigned to court number 2. Previously, before that, it was assigned to Honorable Mr. Justice Sangam Sangam. Sorry. This matter was filed on 28/8/2023, and before his lord, along with an application for stay to quash the FIR and the proceeding on the ground of jurisdiction. Because I already faced an inquiry at Calcutta because the occurrence took place in Calcutta. And because the informant's husband was an ex-police officer, I mean, police employee, he managed to get an FIR after burning the dead body of his daughter through his wife. So I filed a petition for passing of that FIR along with the application for retreat. The petitioner is one engineer and his old parents. I mentioned on 194959. His lordship accepted the memo and probably directed to list. Thereafter, the bench changed, and then again I mentioned on 13/9/2023 before Honorable in court number 2.
Yes.
Even though I submitted that, with all respect to nothing, that we may be intimate about the either is allowed or rejected or date time. I didn't receive any answer, but that memo has been received. On 13th then till today it is not listed. What I pray, the way my lord is going by, because half of the day he is sitting single, it will take months to get another minimum a month. The serial if it will come, and the old parents are going to going various type of torture now, and the husband is now actually hiding because of the nature of the case. Is out and out a baseless case, and particularly I faced the case at UD case. There was the father of the girl was there. He said, "Have you got any complaint?" He said, "No." So that is why the UD case was closed and it was submitted to the magistrate. And by saying that if any complaint comes, it will be reopened. Instead of reopening at Calcutta, they filed the FIR here. And in spite of the fact that the lady wrote a lot of satisfaction in her own diary.
To the dear.
I've given the memo.
Okay.
May I pardon? Writ appeal 22, it was directed by this honorable court to be listed on 11th September. But in spite of repeated memo to the DR, it is not yet listed.
Already, one thing, there is a problem because of this demeeting office is very close to, we are not taking new matters. So I'm fixing your matter, give the memo, it will be October 5.
But may I
My Lord, I am seeking a review of the order passed by Honorable Justice B.R. Sodaki and Honorable Justice S.K. Mishra, my Lord. Against that order, a contempt has already been filed. I was seeking your Lordship's kind consideration, my Lord.
I cannot take up the review.
No, my Lord. Only a bench has to be constituted on the administrative side.
Then go to the administrative side and ask the.
But may I pardon to mention that the
Just a minute.
Lord, may I pardon to mention that
That is why I am asking you, go to the deputy registrar. I have asked you to report to him so that a bench can be constituted.
My Lord, I'll do that. Obliged.
with respect to the writ
students, this matter is to consider today, but it is not in the list.
What matter?
All right. That I think government has also not filed any reply to that.
not writ appeal The honorable single
From
judge,
the month of October, land council. 9th October.
From tomorrow maybe dispose.
No, 9th October it will come.
your lordship said,
Government reply, we cannot dispose of the matter.
read appeals, may I pardon to mention, my lord, read appeal, the honorable single judge has directed to pay the salary against an abolished post in the interim application and failing which directed to personally appear on 3rd of October. I have filed read appeal, may be taken up.
Let it take it tomorrow.
With respect to your lordship,
16
this is this matter,
22. That is stay order is against me, my lord.
One, please, huh? Yes.
My lord, stay order is against me. I am a retired employee and mentally disabled person. Every day I am meeting medical expenses.
It will come on 9th of October,
My
give the
lord.
list.
your lordship said,
Allow my answer twice on 14th and 21st of this month, but it is yet to be get listed. So Lordship, I pray tomorrow.
Tomorrow is not possible. You just consider that I am retiring on 3rd.
My love.
So I cannot take up many matters. Just you take it on 9th of October, that will be listed on
this
9th
is a
of October.
phrase, this is a phrase matter, your lordship, and your lordship has been pleased.
Distribution matter. My lord, the matter of distribution of writ appeal, I have filed.
Dismissed by whom, but
Just taken up tomorrow.
No, it's not tomorrow. It will be taken on 9th of October.
May I be pardoned?
This is phrase application, your lordship is pleased to direct to be listed on 21st.
Just
it is-
1 minute, yes.
It was directed by your lordship to come on 21st, but it's not listed, my lord, the phrase matter, my lord.
Let it be go to the first week of October.
The urgency that the lordship has been pleased to direct it list on 21st. It is in the list section, my lord.
No, I understand, because they are also finding difficulty, 9th of October.
This is a phrase matter, my lord.
That is why 9th of October.
It's a, whether it's a BL, but he wants a
May I-
constructed building. 9 crores, 16 plus was sanctioned. And in that money, building has been constructed. Now the government is going to give it to a craft institute man. Though the funds have been allocated for the degree college man, degree college building.
9th April.
My lord, recently going to open it here also.
My lord,
Eviction.
Evictions.
my lord,
May I-
pardon, my lord, I am for the respondent. Now, single judge pass order, as a respondent working more than 23 years as a contractual sweeper. This honorable court direct the matter to list the on author 18th. But my lord, this case not listed.
It will come on 11th of October.
And
May-
another matter, my lord, honorable court fixed of that on 27th. So my lord, I mentioned again. 27 already fixed.
They already fixed, who are you mentioning the matter?
Already, my lord,
Pardon, my lord.
May I be pardoned, my lord?
My lord, my date was fixed to 9th October. Let it come on 5th October. I'll go from 8th to November on meditation to Raipur. I will not remain for.
This is done
May I
on
be-
5th of October. it will come.
What I remember, you are saying, this matter, cremated has already disposed of in the month of March. And, I filed a petition for modification in this, matter. Modification.
Passed by judgment.
Direction for, seeking direction for, court.
Which bench?
Which
bench?
This bench only, it has been disposed of. My lords have directed for issuance of a guardian certificate that is not been.
For sale of that property?
Yes. So guardian.
We have already given a direction so far. I recall to the registry to issue the guardianship certificate.
But till now they are not.
Now, what do you want a modification?
Not modified. That is for issuance of guardianship.
So it is better it should not be mentioned.
I'll take up before the.
All that you give this, make the memo and send to the dear and just write on this for issuance of the guardianship certificate.
May I be pardoned, my lord? My lord's writ appeal number 2406 may be called up tomorrow or day after tomorrow, as the impugned order is expected to be implemented on 29th of
Where is the writ appeal?
appeal against
Fresh writ appeal,
fresh. Yes, ma'am.
challenging order, expected to be implemented means what?
Your lordship, 29th.
What?
There's a direction to additional district magistrate.
For what?
Your lordship, to decide the party involvement of parties under Societies Registration Act.
So what is the urgency in the matter?
Your Lordship, the matter may kindly be heard. It's a void order
No, why?
before the implement.
Direction is to be for consideration by the additional district magistrate, means the Deputy Register Cooperative Society.
Your Lordship, it's an impugned order is a void order in violation of Registration of Societies Act. The matter may kindly
Why you explain?
in violation of a law.
What is the violation?
Your Lordship, under
Read properly mention tomorrow.
my Lord's
What kind of a violation? Because it is simply for consideration. If we decide in a particular way or decide in your favor, why?
Your Lordship, it's beyond its jurisdiction.
Whose jurisdiction?
Your Lordship, additional district magistrate.
Why?
Before he has
Under,
explained.
under section 11 of
11A.
yes, Your Lordship.
11A is a court proceeding.
Your Lordship.
Even if this direction from the High Court is there, you can file a suit before the civil court under section 11A, senior civil judge. Because there is a different recourse of law.
Your Lordship, appeal. Your Lordship, the appeal may kindly be.
I will allow you to appeal right now, if you can convince me.
Your Lordship.
Allow it. Just see what is the grounds you have taken and what is the judgment.
Your Lordship, my senior will address to Your Lordship. Your Lordship, fix it today, tomorrow or day after tomorrow. My senior will address.
Cannot. How many time? What is the time given for consideration? Have you read the judgment? Huh?
No, Your Lordship.
Repetition number.
No,
You are not giving any information, so it's very difficult for us.
I apologize for my ignorance.
No, we have no difficulty with your knowledge. Difficulty, you are completely without records. You cannot answer because the record is not before you.
Yeah. Individual pass order and which state petition? Do you have the number?
Yes, Your Lordship.
What is it?
Oh,
Madam, I am a retired person. I have applied for today, but the date was fixed for today. लेकिन वो तो बाहर नहीं आई.
it will come in the next week, first week of October.
Yes.
Sorry.
Huh?
6th.
October, yes.
Your Lordship, writ appeal, writ petition number 24858 of 2020.
This,
24858 or?
so
2023.
on screen.
2023.
That is not listed.
She's giving the number that you want to see.
No, that order.
It is a dispute relating to election, holding of election.
Yes, Your Lordship.
Already completed, you calling
No more than 1 week. 1 6.
it? Yes.
Mention.
I have to mention, Your Lordship, data appeal number 2282. The petitioner the London NGT had passed an order where the petitioner was to face criminal trial, which was stayed by the Honorable Single Judge. And the writ petition has been dismissed on the ground of maintainability, and for which we have filed a writ appeal in this matter. The matter may kindly be taken up.
The order of NGT has been challenged.
Yes, Your Lordship, in the writ petition number. In the writ petition, and it was stayed, but the stay has already been vacated, and the writ petition is also.
What is the wrong in that order?
Your Lordship, it is violating the section 51 of the Green National.
Green Tribunal.
Yes. So, Your Lordship, there was a stay in that matter in the writ petition, but the stay has been vacated, and the petitioner might face criminal trial for it, and also disciplinary proceeding in this matter. So, the matter may kindly be taken up this week.
But I don't think that your case is maintainable. Anyway, list it. Tomorrow. Or 10th of October it will come. Otherwise you cannot accommodate. Okay.
Open. Open. Very good. Madam.
Sorry, you will not entertain because the petitioners filed one representation. The additional district judge, as the ARS, has been asked to consider the petitioner's representation. And there is no order in the past within a period of 2 months from the date of commission of the order. So there is no urgency. It will come in regular course.
Mentioning over one massive comment will be mentioned.
Whether the Mr. Mishra is available here? Subrat Mishra? Yes, Mahapatra? Mr. Lenka? Can they be just contacted? Just contact them. Huh?
Contacting in the meantime.
Press admission item number 1.
May I please ask? Well, the matter was there, if you will assist for last Friday. The petitioner who was selected and continued in service pillar 69-20-21 2011. And now the order has been passed in annexure 3. The relevant portion page 38. The Honorable Single Judge Miller, even without verifying the counter from the state government, accepted whatever order that was passed by the ADF and quoted the order in extenso, and para 8
yes,
indicated that there is nothing to be interfered with. Before that there are 2 appeals previously. My initial application was challenged. Subsequently, I was found to be qualified. Then my selection was made. I was appointed. That is my on 69-2011. And I've been continuing my lord. If you also look at annexure to the first order of the ADM, page 60. That is annexure 1 starts from page 14. The relevant portion page 18. The private respondent's appeal was rejected.
And that has been informed by this order.
That was not affair, my lord, because this order was challenged before this Honorable Court. And this Honorable Court remitted the matter back to the ADM for fresh consideration. And in course of fresh consideration, my lord, contrary to the scheme, if you also look at page 24.
Yes, on the last occasion also I asked you to show the advertisement.
But in the IML at 5, it was, if you also look at that.
Second.
But can we come to page 8, it was in vernacular. The translation
9.
And the relevant portion, page 13. Name of Anganwadi Center, Dalak Ghar, page 13, madam. And the last column, madam, name of the corresponding village Sahi, that is Dalak Gouda Sahi, College Road. I belong to College Road, madam. Even the caveat petition, my lord, was served on me, my lord, with this address by the opposite party. And my lord, can you see the page 16, madam? This order was passed, my lord, immediately after the order was passed by the Honorable Single Judge on 8/9/2023.
Okay.
Asking my lord to hand over charge. And at this juncture, my lord, kindly see that the order passed by the ADM. Page 24, madam.
Filings.
On Thursday, my lord. Since it was not tagged, my lord, this Honorable Court directed.
Please scan.
It is already scanned, my lord, it is available. Now we come to page 27, my lord, the government counter.
Yes.
Page 27, my lord. It starts from page 26, my lord. That is respectively submitted during the objection period as provided on the guideline. Opposite part number 6 hearing as appellant. File an objection stating therein that except her, none of the candidates belonging to AWC area. On the basis of which CDPO Odgaon requested the local RI and lady supervisor to verify and examine the said allegation and report compliance. It is pertinent to mention here that after receipt of the inquiry report as stated above, and the other documents available in record, the selection committee, which was convened on 16/9/2011, selected the respondent of 5 the present petition in respect to said AWC on the basis of which CDPO issued engagement order in favor of the present petitioner, who has been continuing since then. And how many of the things have been turned by the second adjudication by the ADM, page 24. He made a sub-classification of this service of the area, AWC area. Last word, 6 lines.
Yeah, Mr. Bera, are you appearing for this?
I am appearing for the state.
This is Anganwadi, your own guideline says the village. Village is the unit. Now, you are going further narrowing down this definition.
But the advertisement clearly states that the candidate must be a permanent resident of the concerned center village, connected village, or Sahi lane. That's at page 9 of the IS.
She is the resident of the concerned village.
Of the village, but not of that.
Yourself provide the alternatives. How can someone can be restricted on the basis of that you choose up out of 3, 1 choose up for just to have the test whether she is a resident of that particular area?
Had you stated that if candidates not available there, then it may be taken from the village, we can understand. But you put an oblique. Oblique means everybody.
Automatic, yes.
So I don't think this is a very correct position that you have taken. And I do not know how the additional district magistrate passed this order. What is the basis?
Basis of, my lord, the order passed by, or the report by the Tahsildar, my lord. We filed appeal against the order of selection. Selection, they are dismissed. I approached my lord earlier 12. This one decided that the order passed by the ADM not correct. That will give all party and take a fresh decision by measuring the area. Thereafter, the ADM directed Tahsildar to submit a report. Tahsildar, after the verification of the area, prepared that, submitted that the petition does not belong to service.
What is the Tahsildar's report?
That might be also from the government. Because in the order of the ADM, it is clearly mentioned that Tahsildar giving the report. It is by passed the order and this now decided that we is a factual dispute, we cannot decide on the real petition. Therefore, I dismiss the matter and implement the issued the order of disinvestment.
Just wait. You are not the selected candidate.
Yes, I was second one, madam. I put the appeal.
Second one, whether the government will be given to you or not, it will be decided.
Not my directive is a 3 month decide matter.
All right. It's just wait. We are looking into how the ADM come to that inference. Where is that report? Why have you not filed the report with your counter affidavit?
No, the counter affidavit is a very short counter affidavit. I'll take your lordship's liberty to prefer a fresh affidavit.
File a fresh affidavit. Because that has to be looked into. Yes. Because otherwise we cannot touch the learned single judge's order. So we ask them to file the Tahsildar's report. And I'm telling you one thing you just did. Tahsildar cannot just dilute what has been provided in your Anganwadi workers, this manual that I have checked up. This guidelines, para 4 of the guideline that says the village mostly.
Yes, please. Some classification is not permissible.
At the request of Mr. A. Behral, Additional Standing Counsel appearing for the state opposite parties. If the matter be listed on, do it early because she has been already terminated. And you have to also make a prayer, additional prayer for quashing the termination.
Yes, in the IMLR, I've made that prayer.
You have to now to file the appropriate application. I do not know what. All right, I am not. 9th of October or 11th of October? 12th of October. 12th of October. In the meanwhile, an additional counter affidavit shall be filed by the state opposite parties, along with the report of the Tahsildar, which has been relied on by the additional district magistrate while deciding the case of fresh on the basis of the order of remand passed by this court. Am I the correct case? Mr. B.S. Tripathi, Learned Counsel, has appeared for the appellant. And you are Mr. Lakshmikant.
I have held counter.
And also Mr. Lakshmi. What counter?
The objection I have held to the petition matter.
All right.
I have the pack.
Mr. Lakshmikant Mahanti, Learned Counsel, appearing for the. What is the respondent number?
6, madam.
Respondent number 6 has filed an objection against the interlocutory application being I number 4,883/2023. So in view of his accepting notice of the caveator, the caveat petition stands disposed of. Stuff. Meanwhile, the status quo shall be maintained in respect of the
Anganwadi Center, Dalak.
Anganwadi Center, Dalak. And so far the Center Dalak is concerned, and handing over the charge is concerned.
Item number 2.
Yes, Mr. Kunti. It shows the service is complete.
Yes, ma'am.
But someone has come for 5, 6, and 10.
Is Samir Mishra appearing for 7 and last occasion lots.
your lordship directed to take up the matter at 12 p.m. specifically last order.
Oh, then wait, we'll take a wait here, huh? Because he may be.
There.
Ah. So you are ready?
My lord, if your lordship takes up, I will just assist. After the Railway Council answers it, I will assist your lordship, ma'am.
All right.
Ma'am,
Yes.
because my friend is taken up.
Yes, Mr. Kantiya.
Your voice is breaking in between, Mr. Mishra. You have to take that risk.
My lord? My lord, I could not hear.
In between, your voice is breaking, so we might not be able to hear bits of your argument, some bits. Kondu.
May I please, Your Lordship? Your Lordship, turn to page 19, annexure 1.
Yes.
My willingness from eligible constables were called for promotion to the rank of ASI against 20 vacancies. Your Lordship, it is proper to hold a competitive selection test for filling of 20 vacancies of ASI RPF according to the post-based roster point under Rule 72 of RPF Rules 1987 with community-wise breakup, that is UR 17 SC2 ST1. Your Lordship, see the second paragraph. The constables and head constables who have completed 10 years of service on date of notification are eligible to appear in the test under Rule 72 of RPF Rules 1987, subject to maximum 2 chances. Willingness may be called from the Your Lordship, that 10 years from the date of appointment, though we are appointed on 8th 99, that was not taken into account because our training period was excluded. We approved, my lords, in WPC number 667 of 2010. Your Lordship can find it from page 21, annexure 2, my lord.
Yes.
In that case, our prayer was to count our training period for the purpose of appearing the test, ASI test, recruitment test. Your Lordship, as an interim measure, directed allowed to appear the recruitment test, and finally, Your Lordship held that annexure 2, Your Lordship, page, I am reading that relevant portion, my lord. Page 31.
You come to the page 28 of the judgment, where the RPF Rule 63 has been quoted.
My lord. Quoting this, my lord, the honorable court allowed our prayer. And director, Your Lordship,
we will read the rule, then the judgment.
Yes, sorry, ma'am. At this juncture, it is felt necessary to quote Rule 63 of the RPF Rules 1987. Subject to subrule 2, the period of training, including in service course, shall be treated as duty for all purposes. So that means during that training period, it will be counted for the all purposes. But what they did not count the training period when we are on to appear the ASI recruitment test. So, Your Lordship, relying this provision, Your Lordship allowed the writ petition. And Your Lordship, see the last portion of the order, my lord. Page 31.
No, order, what is the wrong though? Even a judgment can be wrong in reading a one rule. And that cannot be a precedent. You know the rule of the
No, my lord, we are not challenging this judgment. I am not challenging this judgment.
No, you are taking support of that judgment.
Yes, I am.
We are telling you, it's a par incuriam. Why should you look? It is against the rule.
Not against my lord. The rule
says that is why I have straight away brought to read the Rule 63.
Yes, my lord. The period of training, including in service in courses, shall be treated as duty for all purposes. But what the respondent did, they did not count the training period.
Okay, that is your grievance.
That was our grievance.
Okay.
When that rule permits, that will be treated as duty.
You are representing 1, 2, and 3.
One.
Only one.
One. Railway.
When that rule permits to be treated as duty for all purposes, the respondent did not count that training period For the purpose of
That is apparently not correct. Mr. Mishra. Sorry. No, Mr. Khuntia, no. No, Mr. Mishra is not appearing today.
Yes, Mr. Appear is appearing virtual.
Okay.
Telling the voice is going off in between.
No, I was looking before us, but you are before your camera. Okay.
I'm sorry, man.
You are appearing for Mr. Mishra. You are not appearing for one. I think you are appearing for two.
I'm appearing for two. My learned friend is standing before you, appearing for one.
Okay.
I'm standing before you. I'm sorry. For one, my lord, my learned friend is appearing before your lordship, my lord, physically.
You are appearing for the East Coast Railway, my lord. What is your good name?
Chandrakant Pradhan, my lord.
Yes. You appeared on the last occasion also. You are the CGC.
Senior panel counsel.
You are well the interest of these individuals. They have been selected already.
No, what has happened? The dispute regarding intercession. This is not the subject matter of challenge. I am coming. This is the first rate petition where your lordship allowed our prayer and directed to publish the your lordship that in compliance to that interim direction, your lordship directed them to permit us to appear in the recruitment test, and accordingly we appeared. Then finally, your lordship at page 31, your lordship's direction, law is well settled that when the statute provides for a particular procedure to do an act, the authority has to follow the same and it shall not be permitted to act in contravention of the provisions of the statute. It has been hitherto uncontroverted legal position that where a statute requires to do a certain thing in a certain way, the thing must be done in that way or not at all. Other methods or mode of performance are implied and necessarily forbidden. The aforesaid settled legal position is based on a legal maxim universe altris, meaning thereby that if a statute provides for a thing to be done in a particular manner, then it has to be done in that manner and in no other manner, and following other course is not permissible.
That order was not challenged?
No, that was not challenged. This against this, they filed a review petition. Review was dismissed. After dismissal of the review, they published the result, LRC page 33.
Yes.
Against 20, I have shown, my lord, the against 25 recruitment was conducted. And this is a limited departmental examination. It's a promotion from the departmental candidates.
Yes.
LRC against 20 vacancies, 12 candidates were selected. Page 33.
Yes.
Then, what has happened? Similarly situated persons, they also approved, my lords. That is in page 37.
And what happened there?
Yes, ma'am. That writ petition was also allowed. The LRC page 37.
By the same bench.
By the same bench. But in a different, the date is that date is important. Why I am showing the date? You'll also see the date 12/8/2011.
Yes.
Well, you'll also see that paragraph 8, page 42. In our considered opinion, petitioners are entitled for relief as has been granted in the aforesaid two writ petitions as the said benefit was denied to them in the earlier examination, though some of them are admittedly senior to the petitioner in the earlier two writ petitions.
You are reading from where?
My page 42, my sorry.
42 is a part of their judgment.
Yes, my the second writ petition filed by similarly situated persons.
That is.
I am reading that. Let's see, got it.
Yes.
In our considered opinion, petitioners are entitled for the relief as has been granted in the aforesaid two writ petitions as the said benefit were denied to them in the earlier examination, though some of them are admittedly senior to the petitioners in the earlier two writ petitions. Well, therefore, we direct the opposite party to conduct examination in accordance with law, inviting application from eligible persons, and after publication of the result, the correct place of seniority must be maintained amongst the persons who will be found successful vis-a-vis the persons who are selected pursuant to departmental examination held on 28/4/2010.
Yes.
I am showing my lord's date, my lord, that was the order passed on 12/8/2011.
Yes.
My lord, prior to this, they have conducted another examination. They started the process on 11/8/2011, that page 35.
Yes.
I said, here, my lord, it is proposed to hold a competitive exam test for filling up 29 vacancies of assistant sub-inspector RPF according to the post-based roster based on Rule 70 with community breakup that you are 23, SC 5, ST 1. The selection will be.
Why are you referring to this? This certification is of 2011 also.
My lord, sorry. No, my lord. I have shown my lord's page first, page 19, that is of 2009. Lord's page 19.
Oh, that earlier.
Yes, my lord. That 30/10/2009, the first selection process. As you got it, page 19.
Yes.
30/10/2009. Their result was published, LSMSC 8/8/2011.
12/8/2011.
8/8/2011. Result was published. What I am submitting, my lord, 3 dates are important. First date 2009.
Okay.
We all are the applicants in response to the first recruitment process. That is started on 30/10/2009 in respect of 20 vacancies.
And then result was published on?
Published on 8/8/2011.
All right. Right.
Then another recruitment process was started on
11/8.
11/8/2011. That vacancy, 29 vacancies. Out of 29 vacancies, 80 vacancies carry forward vacancies and 21 vacancies of the current year. Also got it, but first 20 vacancies, out of 20 vacancies, 12 filled up because of 12 were qualified in that recruitment test. 8 remained vacant. So in 2011, the next recruitment, that recruitment date is 11/8/2011, page 36.
Yes.
So, this is a complete separate recruitment test conducted on 11/8/2011. So, order of this honorable court come on 12/8/2011, just one day thereafter. Though they are, your lordship are directed to conduct a stress test for the persons those who have approached my lords.
What is come to the part of the judgment? What is
page 42, my lord. In our considered opinion, petitioners are entitled for relief as has been granted in the aforesaid two reports for your lordship has seen that Annex 2. As the said benefit were denied to them in the earlier examination, though some of them are admittedly senior to the petitioner in the earlier 2 read petitions. Therefore, we direct the opposite party to conduct examination in accordance with law, inviting application from the eligible person, and after publication of the result, the correct place of seniority must be maintained amongst the persons who will be found successful vis-a-vis the persons who are selected pursuant to the departmental examination held on 28/4/2010.
Yes.
My case before my lords, there was no recruitment test was conducted in compliance to my lord's direction.
That was the natural process of recruitment.
Yes, that was what they have done. That was done prior to the judgment of my
What
lord.
is your prayer ultimately that you want the seniority since you have participated in the first selection process?
Yes, that
those people will be the selected by the subsequent of the fresh process, they should be below you.
Yes, my lord.
That's all.
Yes, my lord. Why your lordship has seen the first recruitment test against 20 vacancies. Out of 20, 12 filled up. The next recruitment, 29 vacancies.
Yes.
29 vacancies, 8 vacancies of 2009-10 and 20 vacancies are of 2011-12.
All right.
Then your lordship has seen the result, where the result was published.
Whether they have determined the interest seniority.
My lord.
Whether they have determined interest seniority.
Yes, my lord.
What is that?
Yes, my lord. That I am coming. Your lordship has seen page 10, sorry, 55. A result of subsequent test, which was held in response to the 11/8/2011, was published declaring 29 persons, declaring 29 persons to be qualified for the post of ASI.
Yes. When the result was published on this?
28/10/2011, my lord.
All right.
And prior to that, I will show another date, my lord, page 54.
Yes.
We are sent for training on 28/9/2011.
Lord Counsel, how this can happen? First of all, that you have no responsibility. Court doesn't say that you march two separate set of recruitment together.
Yes, my lord. Challenging the order, your lordship may kindly glance at page 82, the order which is imputed before your lordship.
I will come to that. I will clarify. We are sent for training on 28/9/2011, page 54. Then on page 55, on 28, 1 month thereafter, the result of the latter test was published, declaring 29 candidates to be qualified for the post of ASI. After publication of this result, those who have approached my lords in the subsequent writ petition, some of them could not qualify. They approached my lords in a separate writ petition with a prayer, as they have secured more marks than us in the earlier test, they should be declared qualified. In that case, they filed a counter. Since two separate examinations have been conducted and two recruitment tests are complete separate and for complete different years of vacancies, so they cannot be compared together. And their writ petition was also dismissed. They approached my lords in WPC number.
Oh, they dismissed whether they filed any appeal.
Yes, my lord. I am coming to that. That writ petition was dismissed, holding since two recruitment test was conducted, so they cannot compare with the earlier test.
Exactly. Then what happened?
They approached my lords in writ appeal. That was writ appeal number 294, 310, 311, 312, 313, 304 of 2018.
How many writ appeals are there?
Yes, my lord.
How many writ appeals?
I have 1, 2, 3, 4, 5, 6. 6 writ appeals.
6 writ appeals. Just kindly give us a slip with the whole.
I'm giving that order copy. Those writ appeals have been disposed of.
What is the direction there?
Direction. They will not claim seniority. Their representation will be considered.
So how you are affected by that?
With that, I am not affected.
Then
I am affected by the where I am affected.
Only because of that seniority gradation list.
Two writ petitions were filed. We filed one writ petition claiming seniority, and another writ petition was filed. They are claiming parity with us. Their writ petition was dismissed. Our writ petition was also dismissed.
By this order?
No, but not by this. By
separate order.
By separate orders.
Okay.
So their writ appeal has been dismissed. That cannot be said dismissed. That has been disposed on their submission. They will make application of the leaving to the authority to consider.
I think issue is very simple. So when service jurisprudence is concerned, no court can club together the two batches for purpose of seniority.
That is right, man. So far as the WPC number 2558 of 2011,
Then, my lord, the interest dispute, your lordship may see interest is senior to what they have fixed. Page 57.
No, Mr. Kuntia, first of all, let us, the foundational principle, let us first discuss it.
Yes, my lord.
So principle is that two batches cannot be taken together for purpose of determining the
That is the fundamental, my lord.
Then if you have done that, they will not extricate these things. And that cannot happen because it will create a lot of difficulty and complex situation in future also. This is number one.
Lordship.
Yes.
Sorry, Your Lordship.
Yes.
But the ingenuineness of my learned friend Mr. Khuntia, which has created that merger of two selection. That's not correct. I will place the order that has been passed in WPC number 2558 of 2011, which clearly says that in the earlier list that was prepared, eligible candidates who are applied were not considered. So you should consider everybody by taking into seniority their consideration, because the petitioners in WPC number 2558 2011 are seniors to my learned friend Mr. Khundia's candidate. So therefore, what my learned friend...
What seniority now? You are coming to a ladder.
Here
there is any rule.
Both petitioner as well as
Mr. I'm coming to
both the petitioner as well as the private opposite parties are placed in similar footing. When in 2009, when the advertisements were made, all are debarred to participate in view of the rules. Subsequently, some of them came before your lordships, and your lordships observed that they can appear. Meantime, they have already conducted examination and they have applied. Subsequently, we filed a review petition with a prayer to conduct fresh examination, cancelling the examination 2009, because some of them have already been debarred. They are before your lordship now in private opposite parties. Then in my representation dismissed with a direction to conduct publish the result. Subsequently publish the result in 2009 recruitment test. In 2010 and 11, those who are not participated in 2009, they have came before your lordship in 2558 of 2011. In that, Honorable Supreme Court, Honorable my lords have observed that this order, page 42, in considering their opinion, petitioners, the present opposite parties, are entitled for relief as has been granted in the aforesaid two writ petitions, as the said benefits were denied to them. In the earlier examination, though some of them are admittedly similar to the petitioner in the earlier two writ petitions, therefore, we direct the opposite party to conduct examination in accordance with law, inviting application from the eligible person, and after publication of the result,
yes,
the correct place of seniority must be maintained amongst the persons who will be found successful vis-a-vis the persons who are selected pursuant to the department examination held on 28/4/2010, where the present petitions were selected. Therefore, we clubbed both the result.
From the beginning, I appointed 2 dates.
Just a minute. Yes. So accordingly, you have done it.
Yes, madam.
But this order was never challenged before the Superior Court.
No. This order also, one single judge observed that though the order has not been challenged, therefore, in his the order before your lordships is impugned, this court at this stage is not inclined to enter the prayer made by the petitions, considering the fact that a committee has been constituted by the opposite party to look into the matter for fixation of intersectionality. As such, declined to interfere with the decision of the authorities. However, with the observation that the committee, while taking final decision, will take into consideration the direction passed by the division bench of this court in WPC number 2558 of 2011. That is at page 82. That is the impugned order before your lordship.
Yes.
And also this order has not been challenged
This has been it was challenged. He is not
No,
challenged.
no, that 2558 of 2011 order has not been challenged. That has also been taken care of by the honorable single judge. Honorable single judge.
So the final seniority list has not been published. But it is shown that according to the single judge's stated that committee has been framed to look into the matter.
Yes.
Already you have published the final seniority list.
Page 57, man.
This is the final.
This is the
final.
Then what is this observation means then?
And my lord, again, your lordship may see, the honorable single judge has said that the final list has not been published. Again, on which the honorable single judge has said, your lordship may see that next paragraph, my lord friend has not read it.
Yes.
Paragraph 6. By page 81.
Yes.
So far as the contention of a petitioners on merit is concerned, the ground taken by them is that the private operative cannot be treated at par with them by inserting them in the seniority position, treating them the appointees of the year 2009-10. In my considerable view, this argument is not available to the petitioner for the reasons that the division bench of this court, while disposing of the read petition being WPC number 2, has specifically directed to conduct the examination in accordance with law, inviting application from the eligible, and after publication of the result, the correct place of seniority must be maintained among the persons who found successful vis-a-vis the persons who are selected pursuant to the decree held on 28/4/2010. I am not disputing them. I am not challenging the border part in WPC number 2558 of 2011. My contention before my lords that in compliance to order part in 2558 of 2011, no recruitment test has been conducted. They cannot take the plea that the recruitment test which was conducted on 11/8/2011, that is in pursuant to my lord's direction. My lord's direction was 12/8/2011. And 11/8/2011, the recruitment process started in respect of 29 vacancies. If in compliance to my lord's direction, selection test will be held, then at best it will confine to 8 vacancies. Because 2009-10 vacancies are 20, 12 filled up, 8 remain vacant.
Whether this order says there will be the special recruitment drive, that doesn't say so.
Said to conduct a fresh recruit, conduct a test.
And the fresh also with a very unique meaning, in entirety you read, it is not fresh that after cancelling the earlier selection.
Yes, ma'am.
Keeping the earlier selection intact, you hold another selection.
Yes, ma'am.
The word should not be fresh, but another selection.
Another selection.
Exactly.
My submission before my lords, they have not conducted a fresh selection in respect of that 8 vacancies. Unfilled vacancies of 2009-10.
What is the ordinary, the seniority rule in your department?
Yes, sir. That rule 97 of railway protection, the railway protection force rules 1987.
Yes.
Rule 97. Madam, may I give my books if that is. Okay. Okay. The seniority of the promotees shall be determined according to the position assigned. Sorry, my lord. In that, if this is the book, my lord, page 47 is the rule. Universal.
You are saying the rule 97.
Mel.
No, you said 97 is a different page, 49.
This is the 2009.
So this is treated as promotion.
97.
Promotion.
67.
Yes, ma'am. This is the promotion. Well, promotion that in respect of ASI, promotion rule 70 provides that regular promotion. Rule 72 provides limited departmental examination promotion. We are on limited departmental examination promotion. Here also seniority. The seniority of promotees shall be determined according to the position assigned to them in the select panel by the departmental promotion committee.
And that is on the basis of the merit of the total process.
Yes, my lord. Here, my lord, two panels are there.
How can you just compare two panels now?
Only because of personal the orders of this. My lord.
But you have no intention to do that.
No, we have filed a review petition saying that to cancel the process, and though some of the are not, though eligible but not participated, let a fresh examination process be conducted.
But that is not allowed.
Not allowed, and directly publish the data. Subsequently, the opposite parties can be forward and pass the.
Yes. Yes, Mr. Mishra. How can the rule now give an effect to?
I'll just clarify few dates, my lord.
Clarify 2 dates of 2 recruitments.
I'll clarify that.
2 select panel.
I beg to clarify that there has been no case of merger, or that is not there. In fact, in view of 2558 of 2011 judgment, there has been a reconciliation and the selection process has been done with the direct petitionable court, and the judgment passed in 2558 of 2011 stands final because that has not been challenged anywhere.
Yes.
With
yes.
a lot of, I beg to only point out few dates, and both the councils have placed the last paragraph of judgment of 2558 of 2011. I will place few paragraphs more, which will make it more explicit that there has been nothing wrong with the process which has been challenged by my learned friend Mr. Khuntia's client in writ appeal, and the Honorable Single Judge has rightly not entertained their claim. Now, what they have done, before I place the dates, your lordship will see the prayer. That prayer has been made in the writ appeal that they want the 2010 batch should have a separate list and seniority should be fixed, and then the 2011 recruitment should have a promoted recruitment, should have a separate list. But your lordship will find from the fact of the record, their claim is based on the willingness sought for on 30/10/2009. That is in the date chart, first page, your lordship. Now, my lord, by the time this judgment in 2558 of 2011 came into existence, the second list had already been published. Now, in the context of that, your lordship may kindly appreciate the observation that has been made by this noble court in WPC number 2558 of 2011. I beg to draw your lordship's kind attention to page 39. Page 39, your lordship. May I place it? Because the order is to be understood in the context of the factual scenario involved in the writ petition. That is what I beg to draw my lord's kind attention. Here your lordship sees, may I place from paragraph 2, petitioners who are working as constable since 8/3/99 under the administrative control of the opposite party being aggrieved by the action of the opposite party, not considering their cases for promotion to the post of assistant sub-inspector, though they are eligible to be considered for the said post as per judgment dated so and so. But this judgment is taken help of by learned counsel for the appellant. This is their clients had filed this writ petition, have filed this writ petition on various grounds and legal contentions. But this paragraph 3 is very relevant. It is the case of the petitioner that the opposite party issued a letter dated 30/10/2009. This is very relevant, inviting written willingness from the constables and head constables who have completed 10 years of service on the date of notification to appear in the test under Rule 2 of the RPF Rules 1987 to be considered for promotion to the rank of ASI. Petitioners submitted their willingness, this is again relevant, to participate in the selection process. After exercise of option, a clarification was sought for regarding counting of training period for the purpose of appearing in the selection under Rule 72 of the said rules. The opposite party clarified that training period shall not be counted for the purpose of appearing in the said departmental selection. Again, the said order, against the said, some of the batchmates of the petitioners have filed WPC number 6.
These facts are known to us by this time, Mr. Mr. You just can avoid it. The facts are the briefly is that the writ appellants.
I beg to point out.
No, just hear us. That if you find any gap in our description, you can fill up. These present appellants approached that court when the first notification for recruitment was published. Because they are debarred, they were not allowed to participate. Court allowed them to participate in the recruitment process. At that time, you were just sleeping. You were waiting in the ringside. And when they were allowed and the result was published, suddenly you have wake up from your slumber and come to the court, and court was so gracious, allowed you to appear in the examination. They say yes, since you are debarred and other get given, so they will consider you by a fresh recruitment process. Not they say I am cancelling the whole process, it is vitiated. So without raising any objection in view of this judgment, you appeared in the said selection process. Yourself is stating there was no merger of results, nothing of that sort. Now come to this the rules of the promotion, that the seniority of the department of promotees. How these results and the merit would allow the department to fix the position in the gradation list.
May I just clarify one more thing before the rule? I refer to the rule. My lord, by the time the final judgment was passed in WPC number 2558 of 2011, both
2552 or 58?
2558.
2558.
Of 2011, both the syllabi were available, namely the first 2010 and the 2011. What has happened? The present respondents, for your lordships are concerned, they had applied options of the first session 2010. It is not 2011. I beg to humbly clarify. They had applied, if your lordship sees the from 39
I told you they have applied and they are debarred from appearing before the selection stage. Like the present appellants also.
That has been clarified. Your lordship will kindly see this noble code in page 41, paragraph 5. What this noble code has been pleased to observe. May I just place it with Commission? 5, page 41. Our grievance was, despite the fact that we have given willingness, we have not been considered. Now the court says, may I just humbly clarify? This noble code, we have heard the learned counsel for the parties. It is the undisputed fact that the petitioners in the aforesaid two writ petition, in which by the order dated 28/10/2010, this court passed a detailed judgment after going through the rival legal contentions of the parties and interpreting Rule 63 of the said Rule 1987 and referring to various decisions of the Supreme Court, held that the training period of the constable shall be counted for the purpose of qualifying service of 10 years, and further directed the opposite party that they be allowed to take part in the selection process for promotion to the post of ASI, have already been taken the benefit. Against the said order, the opposite party filed the aforesaid review petition, which was dismissed by this court by the order dated so and so, for the reason that the aforesaid order has become final and the petitioner in the aforesaid case have already taken the benefit of participating in the examination. But then paragraph 7, once this court held that the training period should be counted towards the calculating 10 years of service to make eligible to the petitioner to participate in the selection process for the post of ASI, it is for the competent authority to take a decision in this regard, applying his mind, and there is no necessity on the part of the court to make any further clarification. It is clear that non-application of mind of the competent authority, the present petitioners have again come before this court, spending money and public time. In the context of this observation, this noble court directs in paragraph 8, in our considered opinion, the petitioners are entitled for relief as has been granted in the aforesaid two writ petitions, as the said benefit was denied to them in the earlier examination, though some of them are admittedly senior to the petitioner. Petitioners means the present appellants in the matter of two writ petitions. Therefore, we direct the opposite party to conduct examination in accordance with law. This is the direction. Conduct examination with law, inviting application from eligible persons, and after publication of result, the correct place of seniority must be maintained amongst the persons who will be found successful vis-a-vis the persons who are selected pursuant to departmental examination on 28/4/2010. Now, what this to
Mr. Make sure that the facts I have narrated to you, just tell me. Now, there are two departmental panels, select panels. They have been appointed from different panels. Your panel is the subsequent one. Now, how to place you, where to place you, and what will be the parameters to be considered?
This is what I beg to submit. Yes. This concept of separate selection and merger all these things would not have arisen had the railway authority carried out the direction of this noble court in 2558 of 2011 in proper spirit. What I humbly beg to submit, the fact situation of 2558 of 2011 vis-a-vis the direction issued means that there has to be a fresh selection process, including everybody, the 2010 and 2011, the seniority should be determined, but there is a specific direction that the person should be found successful.
Kindly read 87, Rule 87.
Yes, madam.
97, sir. Rule 97.
97, my lord.
97.
My seniority of departmental promotee. The seniority of the promotee shall be determined according to the position assigned to them in the select panel by the departmental promotion committee, and those who fail to qualify in the initial or pre-promotion training course and qualify in the second attempt shall be placed below all those who are qualified in the first attempt in the order of their names in the select panel. I have nothing to quarrel over this. It is not a case that the petitioners have not qualified. It is a case where the present respondents were not considered despite giving their willingness. So therefore, this noble court says, you do it afresh, redo it. So therefore, these two selections, in my humble submission, was diluted by virtue of direction in paragraph 8 of the judgment of 2558 of 2011, where the Honorable Court has been more absolutely explicit and clear, and the direct that we direct the opposite party to conduct examination in accordance with law, inviting application from eligible persons, and after publication of the result, the correct place of seniority must be maintained vis-a-vis the selection that has been made 28 for 2010.
I am asking you a very simple question. 97 provides on the basis of the select panel prepared by the selection committee, and their position will be maintained in the gradation list. Now we get the two sets of gradation list. You are also said there is no direction for the merger. How the authority will act?
May I just clarify with your lordship's kind permission? Yes. My humble submission, the merger, there has been a direction for fresh process. So therefore, both the selection process have been obliterated by virtue of the direction of this noble court.
Sorry. That proposition cannot be accepted. Their selection was not cancelled. They are asked to participate in the fresh selection process. That is why I asked what this order means in paragraph 8 is to hold an additional selection test.
Paragraph 8 is to be read along with the fact, if your lordship finds the fact, we are applicants in 2010, not in the 2011 recruitment, your lordship. Your lordship sees the fact. Fact is in paragraph, my lord, 3.
All right, Mr. I have heard you.
This is the position.
All right, because this judgment, Mr. Kuntia, the position will be directing the DPC should sit again. And they have to prepare according to the order, actually merit. They have to merge these two select panel because this order has not been challenged. It has created a difficulty. And we cannot also touch this judgment. We do not have being the co-equal bench, we cannot do that. So the DPC will select and they will just make a fresh common selection.
Already that the list was prepared. What my lord has seen that rule 97. As per the rule 97, two panels are there. And
now, Mr. Kuntia, you just come. A correct place of the seniority must be maintained among the persons who will found successful. So,
amongst the 2009 batch and amongst the 2011 batch,
this judgment is not saying that. Say that bring all the categories together.
Yes, my lord. What the judgment says that I am showing my two dates. The judgment is 12/8/2011. My submission before my lords, they have not conducted the test in accordance with the judgment. Because if they will conduct the recruitment test in accordance to the judgment, then the vacancy position will be 8. Because
I understand 2012 was appointed.
29.
And now the second recruitment, it was a 29 post.
Yes, but that I'm submitting. Can they mark the 29 post along with the 20 post?
Issue is somewhere else.
Enter issue minus the year of vacancy. In 2009, when we have appeared, there are 20 vacancies. And a panel, that will also be Rule 97, a panel was prepared amongst 12. There is no dispute amongst 12. There is no dispute, inter se. So another panel was prepared in respect of 29 vacancies of 2011, 12, 20 vacancies, and 21 vacancies, 8 carry forward vacancies of 2019. And my learned senior has said that they have applied in question to 2010. I am showing that when they have applied.
Where is that?
Yes, well, I have annexed that document. You also may see when they have applied. You also may see page 43.
Yes.
The date of application 7/8/2011.
17.
17/8/2011. In response to 12/11/8/2011. They have applied against the vacancies of 2011-12, not the vacancies of 2009-10.
This is actually this willingness. I think you have called for the willingness those who would like to appear in the.
Yes, but that willingness was called for on. You also may say that 12/8/2011, 11/8/2011.
Can you show us this letter dated
35
11th of August 2011?
35, madam, Annex 4. That is our case. Enter case is that. If they would have conducted the examination in compliance to my Lord's direction, then they would have conducted the examination in respect of only 8 vacancies, not 29 vacancies. And they cannot say they have conducted the examination in compliance to my Lord's direction. If my Lord's direction was on 12/8 and they have started the process on 11/8, they cannot say that we have conducted the examination in compliance to my Lord's direction. How can they conduct an examination prior to my Lord's direction?
Okay.
That date is page 35, my Lord. It is proper to hold a competitive examination for filling up 20, that I am pointing the vacancies position. 29 vacancies of assistant sub-inspector according to the post-based roster point under Rule 72 of RPA Rules 1987 with community-wise breakup, you are 23, SC 5, ST 1. These 29 vacancies, what has happened? Out of 29 vacancies, 21 vacancies of 2011-12 and 8 vacancies of carried forward vacancies of 2009-10.
Mr. Pradhan, what is your response to that? Because one day before the notification was...
That is my enter case, my lord.
How can it be said that it is the action taken on the basis of the judgment passed in WPC number this...
258.
Can it be said?
That is, my lord, the department has already published a notification. Subsequently, after one day, the order of this honorable court came. And pursuant to that order, already 21 plus 8 vacancies have already been published. Then honorable court directed to conduct examination opposite, therefore direct to opposite by to conduct examination in accordance with invite activities for eligible persons. Though we have already notification has already been made, then pursuant to this order, no fresh examination was required. Therefore, in accordance with law, we have, though we have already prior to one, that is one right position. Therefore, we proceed in accordance with this notification.
All right.
May I just clarify one or two facts that has been made by my learned friend, Mr. Kutia? In fact, they participated in the selection process not after disposal of their case pursuant to the direction of this court. They participated in the selection process by virtue of an interim order passed in the writ petition filed by them. Writ petition was disposed of much after, it was published much after, by which then the second willingness was sought for. Our case was, though we had given in the earlier case willingness, our willingness was not considered. Now the second willingness was sought for during the pendency of the writ petition filed by us, where we gave a fresh willingness. It is not that we gave the willingness for the first time, which my learned friend Mr. Kuntia said. In any event, after the 2558 order was passed, 2011 or judgment was passed, it has diluted everything, saying that you should do it fresh. If your lordship finds that they have not done it fresh, they have to redo it afresh. But now question of 2010 being separated and promoted, though we are senior to them. That is what this noble court has been pleased to observe in 2558 of 2011, that some of the respondents herein are senior to the appellants. And despite that, their case has been ignored. That is what
how does the seniority matters in preparation of the seniority in the ASI post?
Considering promotion, my lord.
Your first seniority is immaterial.
No, my seniority vis-a-vis consideration, had they accepted my willingness offered in 2010.
That first seniority in the feeder grade is immaterial. They say whatever the position that you acquire in the recruitment test, that will be the foundational, the basis for fixing the new seniority position.
So, Lordship will peruse the connected judgments. Everything has been filed by my learned friend in the writ appeal. More particularly, page 92. 92, this merger plea was raised by the present appellants for the Honorable Single Judge. Now, the Honorable Judge deals with it in page 96, Your Lordship, Sopara 2. And the judgment passed by this noble court has been taken note of to hold that there has been a direction for fresh conduct of the process, redo the process. So, therefore, they cannot claim this. That has been rejected. In my humble submission, the observation.
We are examining this judgment, Mr. Mishra. This judgment has been challenged by them.
Fine. So therefore, your lordship will see whether the judgment of the Honorable Single Judge, in accordance with the observation made in WPC number 2558 of 2011. So everything hinges around the judgment of 2558 of 2011, and your lordship may decide the fate of the party.
All right.
And the dates also.
Yes.
The dates also, my learned friend has provided the dates. Your lordship will see the dates, which will have relevance in the case.
Obviously.
I'm grateful.
I think dates are not important at all in this case. And Mr. M.K. Kuntial and counsel appearing for the appellants. And Mr. Chandrakanto Pradhan, Senior Payment Counsel, appears for the respondent number 1, and Mr. M.K. Mishrol, S.K. Mishrol and Counsel appears for the respondent number 2. By means of this intercourt appeal, order dated 27th April 2018, passed by the learned single judge in WPC number 14022 of 2012 has been challenged by the said judgment. The learned single judge has dismissed the writ petition filed by the appellants by holding that. What is the judgment? This is
page 72.
Holding that.
Page 81, paragraph 6, it starts.
And with the lordship's permission,
all right. Holding that the relief is claimed by the petitioner the respondents numbers 3 to 4 no, he was 3 to 16 cannot be treated at par with the appellants. Yes, the appellants and the private appellants, private respondents were selected and recruited by distinctly separate two recruitment processes. The said claim was discarded based on the order dated what is that order? This
2558 Melon. To page 39, 12/8/2011.
39.
Melon.
Order dated 12 August 2011. Passed in WPC number 2558 of 2011. Before we refer to the judgment / order dated 12 August 2011, we need it that a brief perspective has to be placed. So, in terms of the notification, your notification date was?
My notification date is page 19, my lord.
In terms of it is a letter.
30/10/2009.
In terms of the letter dated
just top, my lord.
30th October 2009, issued by the East Coast Railway within Annexure 1, admittedly the appellants applied for a recruitment to the post of the rank of ASIPF in the scale of pay of rupees 5,200-20,200 with grade pay of rupees 2,600.
2,800.
2,800 under Rule 72 of the IPF Rules 1987. Stop. It is also an admitted position that both the appellants and the private respondents were declared debarred by the recruiting authority, as according to them, the appellants and the private respondents did not complete 10 years of service on the date of notification. Stop. Having faced that bar, the appellant approached this court by filing the writ petition being, your writ petition is?
My WPC 6671 of 2010.
What is that?
My page 21.
Being WPC number 6671 of 2010. Stop. What is the line last time? And contended that the respondent number 1 had taken the decision in violation of the rule 47, no?
63, madam.
For rule 63.
Page 28 that has been quoted.
Whereby it has been provided that subject to subrule 2, the period of training, including in-service courses, shall be treated as the duty for all purposes. In WPC number 6671 of 2010, by an interim order, this court permitted the appellants to appear in the selection process as initiated by the later dated 30th October 2009, Annexure 1 to the Memorandum of Appeal. Stop. Thereafter, as per direction of this court, the result was published and it was found that the appellants were successful and accordingly they were recruited. Stop. It appears that being encouraged by the said development, the private respondents also approached this court by filing another writ petition being WPC number 2558 of 2011. Stop. The appellants were not party there.
No, madam.
Stop. In that writ petitions, appellants were not party. Stop. What is the judgment?
Sir, madam, page 37 starts from page 39.
Yes. By the order dated 12/8/2011, said writ petition was disposed of in the following terms. Para 5 at page 41. Quote. You have heard learned counsel for the parties. It is the undisputed fact that the petitioners in the aforesaid two writ petitions, in which by the order dated 28/10/2010, this court passed the detailed judgment after going through the rival legal contentions of the parties and interpreting Rule 63 of the said Rules 1987 and referring to the various decisions of the Supreme Court, held that the training period of constables will be counted for the purpose of qualifying service of 10 years and further directed that opposite party that they will be allowed to take part in the selection process for the promotion to the post of ASI have already taken the benefit. Against the said order, the opposite party filed a forced review petitions, which was dismissed by the court by order dated 3/8/2011 for the reason that the said order became final and the petitioner in the aforesaid cases had already taken benefit in participating in the examination. So, thereafter, it has been also observed that the private respondents have to approach this court as the competent authority did not apply the mind and allow the private respondents to participate in the selection process by which the appellants were selected. So, in this juncture, we must note that the appellants were allowed to participate in the selection process by virtue of the interim order, not at the decision of the competent authority. So, thereafter, in the said judgment dated 12/8, it is 12/8/2011, a division bench of this court has observed and directed as under Code Para 8. In our considered opinion, petitioners are entitled for relief as has been granted in the aforesaid two writ petitions, as the said benefit was denied to them in the earlier examination, though some of them are admittedly senior to the petitioners in the earlier two writ petitions. Therefore, we direct the opposite party to conduct examination in accordance with the law, inviting applications from the eligible persons, and after publication of the result, the correct place of the seniority must be maintained amongst the persons who will be found successful vis-a-vis the persons who are selected pursuant to the departmental examination held on 20th of April 2010. Stop. The private respondents, in terms of the respondent number 1, did not publish any separate recruitment notification, but as on 11th August 2012, they had published a recruitment notification for 29 vacant posts of ASI RFPAF within bracket, Assistant Sub Inspector, Railway Protection 4. Stop. Force. Stop. They sent letter individually to all the private respondents whether they are willing to participate in the said process. The respondent number 1 has stated very clearly that all the private respondents appeared in the said process and came out successful. So thereafter, in terms of the said order dated 12/8/2011, why is this a combined gradation list? Mr. Kantia?
Page 57, Annex 11, well.
A combined gradation list was published by the notification dated
18/1/2012.
18 January 2012, Annex 11 to the Memorandum of Appeal. Stop.
There, our name appeared at serial number 19 and 23.
All right. The name of the appellants appears in serial number 19 and 23, whereas the names of the private respondents finds places in serial number 1, 2, 3, 4, 5, 6, 7, 8, and 11, 12, and 13. So, the said decision of the respondent number 1 had been challenged in the writ petition being WPC number 14022 of 2012, which was disposed of by the impugned judgment dated 27th April 2018 and 13 to the Memorandum of Appeal. There is a next judgment also relevant, no?
Yes, that is relevant. Page 83, the last portion is relevant, madam.
Stop. And what is this judgment? What is the two judgment?
Why to play that another set of employees, though who could not qualify in the subsequent test, they approved my lords in that subsequent case that to declare them at par with 2009 recruitment.
All right. But they could not succeed.
They could not succeed in that.
Right.
Your lordship, page 100.
Got it. Yes. This by the said judgment dated 27th April 2018. Yes, already stated, the writ petition filed by the appellants has been dismissed. Stop. And this is the reason for their filing of this intercourt appeal. Mr. M.K. Kunti, Learned Counsel, at the outset of his submission, pointed out to the judgment dated 27th April 2018, passed in WPC number 1435 of 2012, which was filed by the unsuccessful constable and head constable who could not.
And some of the petitioners in the 2558 of 2011.
And also some of the petitioners of 2558 of 2011 urging this court a series of writ petition they filed. Series of writ petition, including this number that I have provided, including that number, such. So those writ petitions were disposed of by a common judgment dated 27th April 2018. Stop. It has been observed that in the following manner, it has been observed in the following manner. For it can be analyzed by way of an analogy. Suppose 20 vacancies are to be filled up in a selection process, and in the said selection process, 30 candidates have been found to be successful on the basis of the minimum cut-off marks fixed by the selection committee.
23.
And a merit list of 30 candidates have been prepared. Since the vacancy is only 20, then category-wise and after following the roster, from 1 to 20, candidates will be selected and appointed, and the rest of the candidates will not be selected due to lack of vacancy, as such, the successful candidates cannot be said to be selected candidates, and this court, while directing the same to maintain the seniority, which itself suggests that seniority is only after selection, not only after being successful in the selection process. Here the word successful will mean the selection. As such, the connotation given by the petitioner by interpreting the word successful is not acceptable to this court. Accordingly, the same is rejected. Stop. It has been stated by Mr. Khuntia. The said judgment has not been challenged.
No, that last portion, the important part is last portion. In view of the discussion made here, that portion is important.
It has been also observed that in view of the discussion made herein above, and considering the fact that the petitioners are trying to compare themselves with the selected candidates of the selection year 2009 and 10, they cannot be said to be selected candidates. Hence, the reason given by the opposite party number 1 in the counter affidavit justifying the reason of the non-selection, which is secure of lesser marks than the last selected candidate on the basis of the select year, cannot be said to be justified. Stop.
This was challenged ballot that in WA number 304 of 2018. I have given that judgment.
Where?
I have given my last.
This is the judgment.
Yes, madam.
The said decision was challenged again in a series of intercourt appeals, being WA number 294 and of 2018 and others. So by a common judgment, common order dated 1/12/2022, a co-equal bench of this court dismissed all the writ appeals. Not dismissed.
Para 12, 13, 14 minutes.
And by observing inter alia,
Not been dismissed.
Disposed of.
Disposed of.
not, it's all right. We are not inclined to interfere with. What does it mean?
That is right.
How is it dismissed?
It is the direction, right?
Not entertained.
So, inter alia that fact remains that the present appellants did not approach the court, but a subsequent point in time, and in their cases, the division bench of this court passed a separate judgment on 12th August 2011, the operative portion of which has already been extracted herein before. That only required the ECR to hold a separate selection test in which the present appellants could participate. This court did not order that evaluation of the performance of the present appellants would be on the basis of the last selected candidates of the earlier selection test. In that sense, therefore, that the ECR has done is to strictly go by the directions issued by the court in a judgment dated 12/8/2011. The court is therefore not able to accept the plea that the present appellants were unfairly denied the right to be considered for promotion on par with the successful petitioner in WPC number 6671 of 2010. Stop. However, this court had directed the respondent ECR to consider to grant the appellants of those writ appeals for being granted notional promotion as ASI without any claim to seniority vis-a-vis the private respondents.
We are private respondents there.
All right. Without any claim to the areas of pay. So, the private respondents, as mentioned in the order dated 1/12/2022, include the present appellant. Stop. Mr. Kuntiya Learned Counsel has referred to Rule 97 in respect of seniority of departmental, in respect of fixing the seniority of departmental promotees. For purpose of reference, the said provision is extracted below. 97, seniority of departmental promotees, stop, dash. The seniority of promotees shall be determined according to the position assigned to them in the select panel by the departmental promotion committee. Those who fail to qualify in the initial or pre-promotion training course and qualify in the second attempt shall be placed below all those who had qualified in the first attempt in order of their names on the select panel. Stop. Having situated thus, we have queried Mr. Pradhan, a senior panel advocate, appearing for the ACL, that how they have published the impugned gradation list and what they have followed in preparation of that. Mr. Pradhan has fairly submitted that we have to follow the direction. They had to follow the direction dated 12/8/2011, where it has been stated that seniority be fixed according to the seniority be fixed according to the past service. Stop. We have also heard Mr. S.K. Mishra, and its senior counsel, who has submitted that the private respondents cannot be pushed to a separate class or category only because they had appeared in the subsequent recruitment process. So according to Mr. Mishra, they cannot be discriminated in as much as this court had categorically observed they were unlawfully debarred in appearing in the first recruitment process. Stop. Therefore, there is no infirmity in the gradation list is challenged by the appellants. Stop. Even he has strongly supported the judgment of the single judge by which the writ petition has been dismissed. Stop. the judgment dated 12/8/2011 has not been challenged and it has reached its finality. But the said judgment have left some vacuum so far as the rule of fixing the seniority is concerned.
Just point out one more thing with your lordship's kind permission.
Yes.
Honorable Judge in paid one observed that this is also a provision list, so no final list has been published. After that much I
It's already. That I have recorded already. Still. The Rule 97, as extracted before, clearly provides that the seniority of the promotees shall be determined according to the position assigned to them in the select panel by the Departmental Promotion Committee. Stop. The admitted position is that there is two separate select panel and the appellants had been selected by the first recruitment process and the private respondents had been selected by the second recruitment process along with others who participated in the said recruitment process. Stop. Those who were successful along with the private respondents are also not before us. And their seniority, as they have been selected in the same recruitment process, would also be determined in terms of Rule 97 of the said rules. Stop. As in the judgment dated 12th August 2011, no consideration made in respect of this Rule 97. This created an impasse, legal impasse, which need to be answered by this court. Stop. On a collective reading of the various judgments/orders that we have referred, it would further appear this court passed divergent opinions so far the seniority is concerned. In the decision secured by the petitioners of that case, in order to accommodate them in the select panel, as the last person selected in the first recruitment process, according to those petitioners, secured less marks than them. Stop. That apart, what Mr. Khuntia has additionally indicated that the recruitment process was not confined to the person who were debarred at the first recruitment exercise. It was widened up as it was a regular recruitment process, which started by publication of the notification on 11th August 2012.
11, my lord.
11th August 2012, one day before the judgment.
11th August 2011.
11, one day before the judgment dated 12th August 2011 was published. Stop. The private respondents participated voluntarily in the said recruitment panel, which was prepared in the second recruitment process. Their right is there. Someone may be in the select panel in the position number 1. How they can be put over that person by virtue of that judgment? Because their right is flowing from Rule 97 of the rules. Railway Protection Forces, Rules 1987 is amended from time to time. Stop. That apart by the judgment dated 12/8/2011, this court not only has taken note of the Rule 97, but also did not give any guideline how to bring the result or the select panel of 2 recruitment processes. In such circumstances, we are of the considered view, the Rule 97 will prevail over, and we are constrained to observe the persons who did not challenge their debarment at the first instance can observe from the ring side. They cannot be treated at par with the persons who immediately challenge the action of the respondent, though in any other matters they may be equal. As such, the seniority of the first recruitment exercise, as such the persons who were selected by this first recruitment exercise shall be treated as a separate class, as the past seniority doesn't have any role in view of Rule 97 of the said rules. Stop. Having regard to this direction, a fresh gradation list shall be published, and consequently we set aside. This is a 1511, what is annexure?
That annexure 13 is the judgment.
No, your gradation list.
Well, that is 11. That is annexure 11, page 57.
The gradation list published on 18th January 2012, annexure 11 to this memorandum of appeal stands set aside. Stop. The respondent number 1 shall treat the select panel.
The order of honorable single judge may be set aside, my lord.
That is a finally. And just what is the last line? No, the first selection of the first recruitment exercise and second recruitment exercise differently, and in order to prepare the gradation list, the Rule 97 of the said rules shall strictly be followed. So, as consequence of those observations, we set aside the impugned judgment dated 27 April 2018, delivered in WPC number 14022 of 2012, etc. So, the appeal is allowed. No order is to cost. Mr. Mishra, go to the Supreme Court. There is a good ground for you just I am formulating that by virtue that I have disturbed the judgment of the...
His client has been imposed the punishment of premature retirement.
That is a separate issue and not concerned. No, because otherwise we are really invading the rights of the persons who have been selected with them. They were not part of the earlier writ petition, not part, here also. All right.
The petition on by your lordship's decision and
Yes.
subject to what obligement.
All right.
Item number
The writ appeal 304? Achi got connected.
I do not.
There is another writ appeal.
Because somebody has given us a note in writ appeal 304 of 2018.
Your lordship, the list doesn't show that.
304, but that has been disposed of. That I have given that judgment that 304.
Given that note, that's why.
So 304, that connected matter was there. So that has been disposed of on earlier. That I will also report that judgment.
All right, but you have given the note in that writ appeal. That is the problem. Confusion created by the name.
Item number 3.
May I please? This is a case where the order under Annex 6 passed by the learned single judge.
What happened to the condonation prayer?
Well, that is not yet allowed by your lordship.
Notice was not issued?
Notice was not issued.
Not issued.
Not issued. It's a case relating to, it's a case relating to order of the state level scrutiny committee cancelling the caste certificate, which resulted into this dismissal of service of a person who was engaged in the year 1990 in the year 2023. So this is the case, my lord, where, my lord, the SLSC order is under challenge. And the main ground, my lord, the SLSC order was on the basis of a report furnished by the police officer on the basis of unsigned witnesses, unsigned statements of witnesses, and that became the basis for SLSC. And now that finding has been approved by the Honorable Single Judge.
Learned Counsel, the Laveti Giri of 1995 Supreme Court.
Right.
After Kumari Madhuri Patil, that was the second judgment.
Right.
It is a comparatively an elaborate judgment where the Supreme Court says the person against whom the investigation is directed,
yes,
he has certain rights,
yes,
including the right to call those witnesses whether they have stated so or not.
Exactly, my lord. That was my plea all through.
Yes.
That has not been taken note of by the SLSC. In my reply before the
SLSC is not supposed to take note.
Even before the Honorable Single Judge, I have taken that as the plea so also in the report.
Well, you have asked to call those witnesses.
Yes, my lord. I have, you will also kindly see, I have taken that.
Today I cannot do anything. I have to issue this. No private respondent?
No private respondent.
I think you will not oppose 45 days delay.
No, not at all.
Already, let us see. Heard Mr. Vishwajit Mohanty. Vishwa Bihari. But here, Vishwa Bihari Mohanty. Learned Counsel appearing for the applicant. This is an application, the 3620, for continuing the delay of 45 days and preferring the intercourt appeal against the judgment dated
10th of April 2023,
passed in WPC number 26631 of 2013 by the learned single judge. So there is no hurry in the matter. You are waiting since 2013.
No, protect.
All right.
Well, that is the imprimand granted by this Supreme Court on the basis of which I am continuing. I was continuing till today, till this order passed by the learned.
All right. But at the instance of Mr. Mahanti and counsel written to the applicant, we have examined the causes assigned for explaining the delay. But Mr. A. Behra and additional standing counsel, having appeared for the opposite parties, have stated fairly that the prayer for condonation of delay will not be opposed by the opposite parties. So, having taken note of the concession given by Mr. Behra and additional standing counsel, we allow this application by condoning the delay as aforementioned stated. Stop. In the result, this application stands disposed of. Next, in view of the order passed today in WIA number such and such, this appeal has been taken up for consideration. Part such and such, only the name of the appellant. And for the appellant, admit this appeal to be heard on merit, issue notice, since Mr. A. Behra and additional standing counsel appears in which notice for the respondents, no formal notice is called for. So, Mr. Behra is requested to bring the SLSC proceeding notes for examination by this court. It has been stated by the parties during the pendency of the writ petition, the appellant has enjoyed an interim order, and on the basis of that, he is still continuing the service. In view of the admission of this appeal, we direct the opposite parties to maintain the status quo as on the date of passing of the impugned order of the SLSC. Stop. In view of that, the IA number 3618 of 2023 stands disposed of. An urgent copy, such and such.
Okay. May I only show your lordship one document?
You please on the day of hearing.
As you
because now in 2011, law has also taken a turn, different direction.
The order of the SLSC can be sustained even by ignoring the oral evidence. Primarily only based on documentary evidence it can be sustained.
There is an admission of the appellant.
My lord, there is a school certificate. That school certificate says his name is Joseph Barik, son of Rajendra Barik, and this certificate is dated April 1983. He claims that he converted to Christianity in 1994. In 1983, there is a certificate that says his name was Joseph Barik.
So that doesn't. That
83.
Okay.
One of my friends' name is Arnold Bhattacharjee. What do you say? Is he Christian or Hindu?
Well, it's because his claim is on the basis of an ROR, which says the name of his father is Rajendra Gonda. So there is a distinct difference between the ROR and the school certificate.
I think so far I have understood from his submission. He is challenging the process that you have followed.
Lord.
Maybe there is material. He says I should be given the opportunity equal to this police officer who investigated the matter. An unsigned statement. He was not recording 161 statement. It was not a criminal investigation. The statement must be signed by the person who is making the statement, taking the responsibility of that statement. Otherwise, it cannot be treated as a document on the basis of which you can draw any inference or draw a finding. Then there will be the death of the principle of natural justice. That is what will be examined. That is why we have admitted it.
Okay.
Yes. Is the matter on the 3rd of November? 3rd of November, Mr. Behra is okay?
Second November.
2nd November.
2nd November.
Okay.
Item number 4.
It has been filed by the state with a delay of 100 days.
Notice to go then.
IA 3866 of 23 at Class A.
Just IA number 3866 of 2023. This is an application for condoning the delay of how many days?
100 days.
Of 180 days. In filing the intercourt appeal, challenging the judgment and order dated 7 December 2022, caused by the learned single judge in WPC number 31431 of 2023. Issue notice as to why the aforementioned delay shall not be condoned as prayed for, or why other orders shall not be passed, having due regard to the circumstances of the case. Notice is made returnable on 11th of November 2023. Steps for service. 13 steps for service on the sole opposite party shall be taken within 3 working days from today by registered post with AD. Next.
Item 5. May I please, Your Lordship?
Just an interruption, my lord. This item 3, it is Jacob Barik says just now I came to State Council. It is a ordnance factory is a party and he has not sought the copy of the same. Lordship may note down all these things. Status order was granted. The caste certificate.
Oh, caste certificate.
Yes. He has given a false caste certificate that order was passed by the court. Thereafter, just come to this writ appeal.
Just a minute, let me check it again. Where is the clerical council has left it?
OP number 4.
OP number 4, the general manager, ordnance factory, my lord.
Do you have any objection regarding this condonation? 45 days delay.
Yes, that is notice.
No, notice we have condoned the delay because I thought Mr. Behra is representing all.
Let Lordship pass the order, then.
All right. Then the record, Mr. Bhutta, you are appearing?
Yes.
This is other 3 order, Mr.
For the OP number 4 only.
Mr. B.R. Bhutta is appeared for the opposite party number 4. They have also not.
It's a very interesting case, my lord. This for
Number of requests are pending.
more than 8-9 application question is in fact.
Already they will be hard. You only said that. Stop. We direct Mr. Mohanty, council appeal to the to supply a copy of the memorandum of appeal with the copies of the interlocutory applications to Mr. Gupta within 3 days from today.
Item 5. May I please, Your Lordships? In the given case, my lord, the petitioner has filed the present review application seeking the kind indulgence.
This one, I think. Sanjay, that. 5 is first come straight to the order that you seek review.
What happened to
My lord,
four?
the order is passed without.
What is an appeal that we have
So
admitted?
Bihari Mahanti was 3.
Next one, limitation notice issue.
Yes.
State.
He has come to the appeal order.
Paragraph number 5 of the order.
The Annexure 6.
Yes, my lord. Annexure 6, it is page number 27. Direction has been issued to the opposite parties. This paragraph, the sixth number line. The opposite parties are directed to ensure that the government land is not encroached by unauthorized persons. The said representation dated 17/5/2023 under Annex 6 to the petition shall be considered in terms of the above observation within 3 weeks from today, my lord.
Yes.
In the present, the said petition, I was made an opposite party and I was the encroacher, my lord. So the relevant facts were not brought to the kind notice of this honorable court.
Yes.
What happens, my lord? Via Annexure 4, my
Are
lord,
you just squatting over the government land?
it is 5 decimal of land because of inadvertent measurement by the local Amin that was encroached and the construction has been completed, my lord. But the interesting fact is that My father has donated 40 decimals of land.
That is a separate issue.
I'm just bringing, with respect, I'm bringing to the kind notice of lordships. I have donated, my father has given 40 decimal of land to the school, and the school building is there, my lord. Despite that, my lord, the land still stands record in the name of my father, as on date. Despite that, 25 decimal of present petitioner's land is being utilized as the playground by the school, because the school has no other landed property.
Why you are bringing this fact?
With respect,
you are allowing them, Learned Council.
Kindly
not relevant fact at all. We confined your submission regarding the government land, which, according to the petitioner, you are unauthorizedly occupying.
You also kindly appreciate only one thing. Taking all the facts into consideration, large number of village people, so also the local representatives have represented to the collector, my lord, to consider the grievance of the petitioner in a just manner.
We are not stopping to consider.
That is pending, my lord. So that was not brought to the kind notice of this honorable court.
We'll observe that in the
my lord. Reasonable opportunity be given to the petitioner.
That is so.
He can be given opportunity.
The collector is always at liberty to settle the leave or to allow him to continue after consideration all circumstances. I only say generally they should not allow some people, because if there is a special circumstances for which you may consider.
My lord, he is admittedly an encroacher. There is no document. There is no document on record to show that he has applied for, because there is a paraphernalia, there is a procedure. He has applied for settlement under OPLE Act or something like that. There is no such record available with this review.
Annex 4 is pending. Annex 4. That is the collector.
Representation.
Yes.
No. Representation will never be mediated to settle the land. For settlement of the
I think what is his anxiety is that this order may have stopped any opportunity of the settlement to the collector also. That part will open only.
Your lordship may say that sub-collector will take into consideration
the rules and regulation that might do. Yes. Is there already? You are Mr. Siddharth Prasad.
You were not there, but you were not there if the bill was heard.
No notice.
Thereafter.
No notice was given to him. Without issuing notice to the present petitioner.
The only in the order, if there was there had to have been a direction that the sub-collector will hear in all the cases your lordship is, but in this case there is no such order.
There is no occasion to file the review petition.
Yes.
All I had Mr. Siddharth Prasad Das and counsel appearing for the review petition, and also heard Mr. D.K. Mohantilan, additional government advocate, appearing for the state. So Mr. Das Learned Council has pointed out that in the order dated 2nd August 2023 as passed by this court in WPC number 19497 of 2023, this court has directed inter alia as follows. Quote, the opposite parties are directed to ensure that the government land is not encroached by unauthorized persons. The said representation dated of 17/5/2023, Annexure 6 to the writ petition shall be considered in terms of the above observation within 3 weeks from today. Unquote. According to Mr. Das and Council, this observation may be interpreted by the collector that he has no power to allow any settlement in the appropriate cases. Stop. We are persuaded by the said submission of Mr. Dastan Council. Even we have also heard Mr. Mohantil and original government advocate on this point. Stop. Having considered all aspects of the matter, we direct the above direction shall not bar the collector to consider either to settle someone on the government land or to grant a special lease to utilize the government land. Stop. No, special leave to utilize the government land. Stop. This order shall be treated as a part of the order dated 2/8/2023. In terms of the above, this application stands allowed to the extent as indicated above.
My lord, in that order, direction was given to the sub-collector. So it is better that in this order also sub-collector Ganjam.
Till then, the interest of the petitioner may be protected, my lord.
Nothing has been directed. So what will be protected?
No.
There were only representation was there.
Consideration at this stage, he may file that I have no claim the court has given to just
Take courtesy measure against the petitioner.
That's a protection he doesn't deserve it. Right? This collector, you go to the sub-collector, you pass any order.
Urgent copy, I pray for lots.
Urgent copy. It be. No prejudicial order, huh?
Item 6, depluralize the lordships.
Is it not?
Item 6 will take some time.
Not today, then it will.
Only our grievances were responding. There might not be regulation of laboratory technician. That's a challenge and
the problem is it will take time. We don't have time.
No, madam,
some other day on this 9th of October, I am proposing.
Yes, my lord may do that, but one thing is that in the meantime, my lord, now they have already issued an advertisement to fill up all this post against which we are continuing.
It will take at least month's time to complete the selection.
But it may not be because on 15/9/2023, they have issued an advertisement to fill up all the posts. So, my lord, they have filed the writ application. And now, my lord, there is delay and also delay in filing the writ appeal. And in the meantime, my lord, when the matter is pending, now, my lord, they have issued the advertisement. So, my lord, ask them about the proceed with this.
9th of October, and you do not disturb their engagement.
Till disposal of the writ.
Till disposal of the this.
Not to proceed with the advertisement.
No, that will not do. They will not take any active decision. We do not know what will happen in the appeal. How can we pass it? This will be not to proceed means you are deciding finally.
No, my lord. What I beg to submit, my lord. Now the writ appeal is pending. In the meantime, for the said,
say this is your position. Your status quo will be maintained by the government.
Yes, that
the writ appeal is decided. What more you require?
We require for our regulation because now they are not available.
The judgment is there. We have not stayed the operation of that judgment.
There has been stay.
There's been stay?
Yes, ma'am.
Stay, your lord.
It was a delay. Delay, but without issue notice, delay has been conducted and some cases late.
Order dated 9/9/22.
9/9.
19/9, sir. 19/9/22.
In one case, the stay order has been granted and by condemning the delay. We are all in several cases where no.
No, these are the urgent cases we issue because otherwise the entire thing will be.
Well, the lead matter is the second matter, writ appeal number 687 of 22.
No, that is not so. So it has been interim order also.
687.
687 of 22, that is the lead matter.
That was also state.
But that is also the interim order stay was passed. Now
886 also there is a stay.
That was stay order was passed in 19 September 2022.
22. The order is December 2021. My lord, during the pendency of the writ petition, they have filled up 1,000 number of posts. Now what happened, my lord? Again, they are now going to fill up 921 posts. They have already filled up 1,000 posts, even after your lordship's order, judgment.
There is no IA advertisement. I don't know instructions whether it's either.
IA also bringing all these things that are published.
Yes, my lord. That is IA number 6716 of 2023.
In which the first matter?
In arising out of writ appeal number 1343 of 2022. In my application, I have filed
1343
of 2022. That is there in the list.
IA number?
6716 of 2023.
Not on record. Writ Appeal 1343 of 2022 has only two IAs of the year.
But 6716 I filed on Friday.
Oh,
I filed on Friday. I have also reserved. I have only signed a copy. That is there.
copy was also must be in your office. IA also
Yes,
must
yes.
be there in the office. It's not there in the record.
Only we pray, my lord. My lord, now it is not possible.
Their applications.
But we are ready for hearing. Your lordship may fix it to an early date, maybe 6th or 5th or 6th of October.
Now, in the meantime, if they will proceed and
That protection will grant.
my lord, kind of grant.
Let the matter be listed on 19th of October is all right. No, 12th of October.
We are ready, your lordship.
12th of October is agreed with the council for taking up the appeal for final disposal. If the appeal is ready for final hearing. Stop. Meanwhile, the appellants are restrained for filling up of any post in terms of the recruitment notice.
Your lordship may clarify as to which advertisement, because
there are several advertisements. This, give the copy of the advertisement because the file is not with us. In terms of the short advertisement number IIE -30/2023 -702 C/4SSC dated 15/9/2023. For the next item, the last item.
Item 7.
Item 7, also already last occasion, I have completed my argument. A small issue, after the single judge, the petitioner has, the present appellant has claimed for particular scale of pay for getting trained to scale of pay.
Mr. Jena, go to a safe day so that matter can be heard.
Last occasion also already.
I understand, but because I'm now pressed by time only that I cannot decide any matter. May it be on 11th of October. I will maximum is for disposal and recording it. Mr. Songram General and Council appearing with the appellants assigns urgency for disposal of this appeal. Stop. Let the matter be listed on 11th for disposal. Mr. Mudali, 11th. Mr. P.K. Mudali appears for the respondents.
My lord, may I make a small prayer, your lordship? Item 10, your lordship. That your lordship has already heard. Many of them.
Very difficult. Very difficult.
My lord, my prayer, your lordship. My lord, only my prayer is that, your lordship. Your lordship has already heard it. Let my lord hear this matter tomorrow. If your lordship will decide that it will be urgent, it will be urgent. Let it come. Let it come.
On behalf of Mr. Mahapatra, my lord, Mr. Mahapatra, from tomorrow, my lord, he will not be available because his mother-in-law is.
I think that will go to 11th of October.
No, I don't dispute your lordship. We have already filed. Just a minute. We have already filed our 18 note of argument. It is regarding.
Mr. Mahapatra will not be available.
He is there, your lordship. He is there, your lordship. He is there.
No, he is not authorized to argue the matter. Let the matter be listed on 11th of October 2023 on accepting the urgency shown by Mr. A. Mistral and Council appearing for this appellant.
Appellant, your lordship.
All right.
The interim order may continue.
The interim order is passed earlier, shall continue.
Right.
Lord, I am pardon to mention, Lordship. I am sorry.
No mention right now.
Item.
Let this item next matter.
Just let the matter take.
But the next matter is very urgent. In as much as the ASI, Archaeological Survey of India, has expressed serious concern about the safety of Lord Jagannath temple. We have only 2 paragraphs of the counter. You will accept a call it tomorrow. It's already 1:15. Let it be taken up tomorrow. Prayer mirror to inspect the yes. But that case the ASI, so far as management is concerned, but my director there is nothing to management. Tomorrow we'll argue. I have a right to argue first. Let it be my
don't just charge the environment. We are already very strict.
I know not, but
all right.
As the partner duplex.
Lordship, item 9.
Lordship,
item 9.
Yes.
Lordship, item 9, WPC number 14057 of 2022. The Wildlife Society matter. That may be de-tagged, Lordship, and it may be fixed for a hearing. Because there is a stay order in respect of NGTs also.
Lordship, item number 9, the main matter may kindly be taken up, your Lordship. If your Lordship is not able to take the time because of the paucity of time, your Lordship may fix up the date. Item number 9.
All right. No, London Council, Mr. This Pani has stated that yes, detect from the item number 10. No.
Item 9.
Item number from which case?
Item 9.
Item 9, Lordship.
You are pressing for detaking from which case?
Yes, Lordship. WPC 14057, the last sub-item.
I would affidavit for file question.
The last sub-item.
I would affidavit.
Last item, WPC number 14057 of 2023.
Yes.
Okay, Mr. SP Panilan Council appearing for the Wildlife Society of Orissa. Respondent has stated that this petition is anyway connected with the other writ petition of the bench. This writ petition be detected. Who is appearing for the petitioner here?
My lords, the state has filed. State has filed this.
No, they want a detagging of the matter.
My lords, our submission is that the issue that has been raised in the petition, because this arises from proceedings for the NGT, my lords, and an order of the NGT was challenged before this honorable court, and this honorable court has granted a stay because execution proceedings are going on. Our central contention is that the issue which has been raised before the NGT is an issue which is before this honorable court in WPC 14706 and the
one thing that we are not going to decide anything on merit.
Please, minutes.
First, the last item, that last writ petition of this batch, according to Mr. Pani, who is appearing for the opposite party, says this is not part, cannot be treated as the part of the batch. Whether we should detail it or we should keep it.
Whereas my humble submission is not be detailed, minutes. Should not be
Lordship, no, order just request now we are already 120. On the next date, you just argue the matter. I am not reflecting anything. We are fixing the matter on 11th of October. Right?
Lordship, Lordship, please.
Yes. Let the matter be listed. So just name give the list of the lawyers. Huh?
I beg your pardon, my lord. I beg your pardon. My lord, on last occasion, my lordship was directed Mr. Sukumaran for that meeting, my lord. And Mr. Sukumaran is recovered from that dengue, my lord.
So no, that is what has happened, and we are informed that this the forest, the principal chief conservator of forest was unwell. He was suffering from dengue.
Yes, well.
He is recovered. Whether Mr. Mohan
Mr. Nair has joined back.
So whether he can organize on 11th.
Mr. Nair would be online also. JTF.
Your Honor, I beg apologies for not being able to attend it.
It's all right. All right.
We are ready, Your Honor. We are ready with We are ready with the presentation and we will be able to do it on the 11th.
On 11th at 4:30, would it be all right for you? 11th of October, 4:30.
Yes, Your Honor. Noted, Your Honor.
All right. It's agreed by the council on 4:30, huh?
Please, ma'am.
The presentation is the presentation which was supposed to be made by such and such is the earlier order. His full name is there, huh? Mr. Nair, huh? Should be made on 11th October 2023 at 4:30 in the new conference hall of the High Court.
Malaj, last order, Malaj had said the old conference hall.
Old conference hall,
required.
old conference hall of this High Court. Registry shall extend all cooperation for this presentation.
Please. New conference hall, old building. New conference hall, old building. I'm sorry. I stand corrected.
New conference hall in the old building.
Lordship, Dr. Nair have visited to a spot 5 days back. So what I request, Dr. Nair may file an affidavit to that effect. He has visited to a spot.
No, all right. He just what he present, you just see, then come to the court with your response. Always. Thank you. Oh no, this one matter is there. Yes. There one matter whether Mr. Subrat Mishra is there. And Mr. Lanka. Huh? Just inform Mr. Subrat Mishra what happened is a very extraordinary situation we are facing. That the respondents has written a very long letter to us directly. That my counsel could not present the case and he has placed the wrong thing, which we don't believe it is correct. But on the face of this, we'll be listing the matter again tomorrow, because I think the council should take fresh this instruction from the client. So list tomorrow. It's expected, I think.
I'll mention tomorrow morning if your lordship permits me. There's a matter, the urgent matter my associate was mentioning was he failed to point out to your lordship that the single judge had overlooked the provision that he directed the representation disposal. The provision is that the amended provision of the Orissa Act says civil court. So therefore it's a void, the direction itself is void. The
amended provision, I think you are section 11A.
Section 11A. Any dispute has to.
Election dispute.
Yes, any dispute goes to the language is this 11A. Any dispute.
Recently, we have passed a judgment.
She has passed a judgment.
In this regard, that when situation is as such, nobody can function. It is an impartial constitutional court to allow the bodies to operate, can direct.
No.
Representation may not be
that is the whole thing. So it was disposed of at threshold without even hearing one side. The first day one, it was disposed of. I will only bring a document, take it tomorrow, madam. Gratefully.
I a little bit asked her several questions because I do not know any young lawyer, even without looking at the brief, should mention before the court.
No,
please allow her to have the brief.
I got the message, she told me. So I got the message, and I'll personally come and make amends before my lords. Grateful, my lords. Extremely great.
Page mentioning, page number 1, item number 1 to 7. Page number 33, item 8 and 9.
I may be confusing item number 9, madam. This relates to that conciliation proceeding and the imposition of court. Even the last person directed me to remind you not to take up the matter ongoing. So if it doesn't reach normal course, let it be taken up at 3 p.m. by the.
You come at 3 p.m. Let us see.
Page 34, item 10. Mentionable.
I beg your pardon to make a mention, Miller. This is a fresh admission matter, PIL matter.
during the fast hour, though I was in the BC but unable to place the matter, my lord. Kindly taken up next week, any date, your lordship.
Not next week, it will go to the October, 5th of October.
Obliged, your lordship. Pardon to make a mention, lordship, this matter lordships had heard on 18th at length as the last matter. This pertaining to the Nirmala institution having been declared as public under section 41. The part of the prayer of the petitioner has become infructuous. Lordship had heard it and specifically directed it to be listed today. However, it has not been listed today. Let the matter come tomorrow at 2 p.m.
It's okay. Okay.
2 p.m. tomorrow.
Okay. They said in the holidays some orders. We'll just try to accommodate. There is some problem, procedural problem. We'll look into this. Huh?
Press admission item number 1.
The matter is related to one cheat fund scam, Ponzi scheme. One company, a group of company, Alchemist group of company.
Have you filed the Okalatnama?
Yes, Lordship. No, Lordship, myself, Deba Rakha. Lordship.
You are having power here.
Lordship.
Yes.
Lordship. Lordship, the group of company which are functioning at Odisha with various offices and each and every block headquarters, they have collected a huge amount of money, almost of 100 crores, but the state agencies have felt that due to their inaction, the money could not be collected from them. Lordship, here the issue is that presently they are having a huge amount of properties that companies are having.
Do you have the Depositors Protection Act in the state?
No, Lordship.
Are you sure?
Yes.
Yes, it is there. That is why I am asking learning council. Approach that authority, not in the
Yes, exactly. On the last occasion, also some petitioners have approached this.
Toby, can you give the full name? Protection of the Small Depositor Act, like that. No, this is the act is name. What the High Court judge will do? He will rush after all these things or hearing the victims.
Exactly, Lordship.
Then next what step?
Lordship,
does he have any power to seize the property or attach the property to sell it out?
No, Lordship, but in the neighboring
there is a statute. Go by the statute. They have the power of attachment. But district judge is the authority who attaches and who has the right to sell out the properties.
But they don't have any property here at Odisha.
Anywhere in the world. There is a procedure how to get the property attached outside even the territorial jurisdiction of this country.
Actually, Odisha Protection of Interests of Depositors in Financial Establishments Act 2011.
Exactly. You just study that act and then
also the Cheat Fund Act. Also the Cheat Fund Act. If there is in coming up cheat fund, the Cheat Fund Act is there. The code is there.
So not These are all the non-registered financial bodies.
Yes.
And if there is a company, then you remedy before the company name.
Yes, sir.
So you just study all these things because general thing cannot be done by a court. Okay.
Paragraph 6, my lord, can see. Paragraph 6, they have stated that the respondent number 12 to 14 are registered and registration number has been issued by register of companies.
Yes.
So the registered company.
And petitioner number 1 is not somebody else. So he has stated that I have reported the doctor to my night some going. Petitioner is somebody else.
And I'm telling you, there is a SEBI has adopted rules also to investigate those are the registered companies are indulging in these unethical activities.
Yes, yes.
Deregister them through the reference from the SEBI. So go to the SEBI side and find all lot of these rules and guidelines. These are all NBFCs.
Another new act is coming. SFI is an organism who are also acted upon this act, and they are also finding this. If any company has committed fraud, then they can the SFI who is taking up the matter. Yes.
But Lordship, on the last occasion, some petitioners have approached this honorable court by one that petition that was 1897 of 2019. At that time, Lordship, there was a commission appointed by the state government. That was exactly the name is not mentioned. That was called a Chick Fund Commission.
It was kind of, I think. No, MM Das Commission.
MM Das Commission, yes. But
because in that time the commissioner was there is a last page 134 and 35.
That's Mr. Author precisely is the point. If you really want to help these persons, or you have stated that you are yourself is a depositor.
Yes, sir.
By moving around here and there, you doesn't help them. How does it help the cause of the petitioner? If you do not undertake the statutory path of recovery or some mechanism where they are regulated.
Let's see.
This is not even a diffuse social interest. It is somebody thinking that he will get large returns. He has invested.
Let's see.
He is not being returned. And you are moving in by you are praying for some commission. Commission could not help, and that has not been extended. I think the tenure of term has not been extended.
Yes,
that is now a thing of past. That itself shows that it is not possible. It is not possible that way to get anything if you are really interested. But there is a possibility that by entering the opposite party you get the benefit.
Mr. Roth, you just approach to this protection of the small depositors act that is here in force. There is a more effective mechanism.
Indeed, Lordship.
You study this laws. Let the matter be listed on 12th of October. You just come back on 12th of October.
Deeply obliged.
Mr. Muduri, are you available? Yes.
For OP number 3, 4, 5, and 7.
Mr. P.K. Purdy. The Secretary of India is appeared for the opposite parties number 1 and 2.
I am appealing for 1, 2.
Yes. Appeared for the
1, 2, 8 and 11.
Okay. 9 also you are appearing SEBI?
SEBI, yes.
9, 10, 11, except 12. So when we request of Mr. T.K. Roth, let the matter be listed and sent. Okay, it will come on 12th October.
Yes. Along with me, Mr. Bhokta will appear.
Item number 2.
Well, it's a public litigation law. But the government sanctioned 1,54,000 some for construction road, that is for improvement of Pidol Road from Pidol Road to Santapada via Sajanpur. But I have taken specific stand, that is para D, that instead of executing the work as per the guideline, as per the instruction government, they have started works in the over plots. Those are objectionable. But I have given the plots number, everything I have given. So my part, I have made representation to the collector. Let collector make an inquiry. So my annexure 6, that is my representation. It is to move the authority. You have to give a certificate. Yes. Annexure 6.
Without placing the demand, how can you file a public interest litigation?
Because this is public work.
For that, you first to public authority. You approach first public authority.
Yes, that is annexure 6. The collector. Annexure collector. Several representations before the authority. So I have given the specific.
Come to your the prayer that you have made before this course.
Where in what?
Yes. To execute the work.
Over the plots for which the worker has been issued. My specific that for which the worker is issued, that should be executed. Not beyond that. But they are doing beyond that blood. Over the Gochar land, over the burning land. So I have given the plots number.
Where have you made the details of
yes, that para D blood. And my representation I mentioned that para D. But so far the worker is concerned, which has been to be started from the Pidol Road to Santapada via Sujanpur, is concerned. The same has to be started from the house of Govind Badik and Tirnath Temple, or village Sirapur and other points like Berashai, all these things, village. So thereafter, the same has to be continued from Sujanpur revenue village and thereafter, and Thaneshwar revenue village, Nuahat, Santapur till the end of revenue village, Santapada, which is within the sanctioned road. But instead of following the said instruction, they have started work over different plots which are objectionable in nature. The plots over which the executants have started working, such as Burningat, that is to plot number 676, 681, Gocherland, and that is all kinds of plots are there. I have given specific stands. So let them.
It's a Patna, that is a guess work. Yeah. Because you have to see, have you seen the detailed project report and the detailed plan of the road?
Yeah, but I have also annexed that also.
Yes, from that and corresponding the plot number and khata number where it is located.
But I have already given that.
The alignment of the road is to go through these plots, this land.
Yes.
Where from you get that, so that this court can at least say that yes, there is deviation.
But
because at best you are apprehending some deviation.
No, not apprehending. I have given the detailed plots number also over my representation.
That you are just in a disorderly manner. You are just.
In fact, my lord, may can see page 9. That is part of the estimate, part of the work order. Page 10 is the map you can see. This is the road position. Completely zigzag.
That is the government project. But I want that should be done accordingly. Not beyond that.
We understand your anxiety.
Right.
No plate I have mentioned. No plot number is mentioned.
Yes, I have given.
D.
Yes, D, para D. I have mentioned.
Para D he has mentioned, as well as in annexure 6 he has mentioned.
Yes,
but in this map there is no mention of any plot.
This is the information that is ask you file a short evidence.
Yes.
By 12th it's already 12th of October.
Yes, 12th.
And Mr. C.A. Patnaik and Council appearing to the petition on allegation has been made in this public interest litigation in the executive agency by defying the project report has been constructing the government road by bringing in the fold some categories of land which are usually not supposed to be included in such projects. So, issue notice since Mr. P.K. Mudali, the national government advocate, appears, and we have notice for the opposite party. Opposite party state, no formal notice is called for. Notice is made returnable on 12 October 2023. Meanwhile, Mr. Mudali shall file a short affidavit on the allegation that has been leveled in this said petition. A copy of this order be supplied to Mr. P.K. Mudali and counsel for faith. Yes.
Item number 3.
But it will come.
12.
Item 3.
Yes.
May I please, Your Lordship? My Lord, we are challenging the illegal and monopoly action of OP number 7, who is trying to go for the construction of Anganwadi center over the PWD land. The land is registered in the name of PWD.
Okay.
Simultaneously, a public road also do exist over plot number 238 by 4548, bearing khata number 329. And they are also going to after that road also. And this is the main road that connects the hospital, Soro Hospital and the railway station. And they haven't got the due permission also from the concerned authority. And the affair has also been lodged.
You read the first cost title. An application challenging the illegal, arbitrary, and monopoly action
of the opposite party.
More particularly,
opposite party
action of the opposite party number 7.
My Lord.
Wherein the said opposite party exercising his colorable power,
my Lord,
finalized the tender for construction of three
number of Anganwadi
center building in PW Godown
area
without following the procedure of law, without getting necessary permission from the PWD and departmental arbitrarily trying. Are you appearing for the PWD?
No.
Huh?
No.
What is the source of your information that PWD has not granted permission and the tender has been floated by an officer of the PWD? What is the source of this information? Is it personal knowledge of the petitioner?
My Lord.
We will ask the petitioner to appear in person. What is the basis of his personal knowledge?
So for the instruction,
first of all, you know, it's a common sense
my Lord,
that unless money is sanctioned administratively, no officer has any right to float any tender. Number one. Before tender is floated, there should be a draft project report.
Now, prior to that, my Lord, on 17/8/23, invitation of bid by the opposite party number 12 for construction of the E type of quarters. That has been, the bid has been sanctioned by the OP number 12 for construction of PWD quarters. In spite of that, now they are going for the construction of Anganwadi workers.
No, we're in the same place. What is the detail of the plots?
Detail of the plot is, my Lord.
Because 3 Anganwadi workers cannot come in the same place.
There is an open space for the godown purpose.
3 Anganwadi centers cannot come within the same place.
My Lord, is 3 to 4
it's not permissible under the program itself. It is one Anganwadi will go to the one village, another will go to the another village.
My Lord.
How you are saying that all the 3s are in the same area where the PW are going to construct their employees' quarters?
My Lord.
How do you say that?
So actually the OP number 7 is trying to go for the construction as per instruction of the 5T secretary. They were given the instruction.
You have a grievance against the 5T secretary. Come that way.
My Lord.
It's a political issue. Why the public regulation?
There is the public road also, my Lord. on plot number 238 by 548, the public road. If they go for the construction of the Anganwadi center, the development.
Council, are you sure that both of us cannot read Oriya?
My lord,
Are you sure that both of us cannot read Oriya? You see your representation, what you have written? And you are lodging FIR for construction of a government building, tender protected by a government agency. And you portray yourself to be a pro bono litigant.
This is a propagative litigations we do not entertain. Even the small cause we entertain. This is a propagative litigation without any system. I am giving you the 5 minutes time, otherwise I will pass the order. We know how to handle these things.
my lord,
I am granting you 5 minutes time to withdraw the petition. Is it clear to you?
my lord.
Huh?
The matter may be taken up next week so that
No,
to
we
get
don't
some.
waste our time. Sorry. You do not know, first of all, what you are just pleading before this court. And score out your political debates outside the court precincts, not here.
I will do, my lord.
Or don't come with this because you are Mr. Dev, Pratap Keshari Dev.
I am Lakshmikanta Behra, LK.
Okay. At the request of Mr. L.K. Behra,
My lord.
and counsel appearing for the petition, we allow this petition to be withdrawn at this stage. This public litigation stands withdrawn, disposed as withdrawn. Of no address to cost. Mr. P.K. Muduli, government advocate is appeared for the state opposite parties. Okay, next.
Item 4. Made to your lordship. My lord, in this case, I am challenging the legality and the validity of the order of appointing arbitrator by the Honorable Court. Now, my lords, it is there's section 2 of the Arbitration Act. If I could take my lord to that, so that provision would clinch the case. Section 2, the definition of Arbitration and Conciliation Act. My lord finds chapter 1, general provision, part 1. In this part, unless the context otherwise requires
just arbitration,
you will not may have a look to E, clause E, my lord. The court means section 2, clause E. In case of an arbitration, other than international commercial arbitration,
yes,
the principal civil court of original jurisdiction in a district and includes the High Court in exercise of its ordinary, original civil jurisdiction, having jurisdiction to decide the forthcoming subject matter of the arbitration if the same had been the subject matter of the suit, but doesn't include any civil court or a grade or inferior of such principal civil court or any court of small causes. Now, my submission is only this. The language is the principal civil court of original jurisdiction in the district and includes the High Court. The article D includes only speaks that is specified High Courts. The specified High Courts, as your lordships know, are only 4. Calcutta, Bombay, Madras, and Delhi. All other High Courts are excluded.
How do you say that the all other High Courts are excluded?
Because my lords, in 2015, and 2007 and 2012, the Honorable Supreme Court, and also in our High Court. They have said that the Odisha High Court doesn't have ordinary original civil jurisdiction. Our court has. Once it is not there, once the courts are specified, and this being a central act, that is why I have.
You will come to section 11, that you will understand that what you are submitting, because section 11 is a special provision creating a jurisdiction.
My lord.
Even this, right, come to the section 11 first.
My lord.
The court word is not appearing in the section 11.
My lord,
yes.
My lord, will find.
Yes.
Section 11, clause 5 and 6. Where
yes, come.
I'm reading clause 5.
Yes.
Failing an agreement referred to in subsection 2
yes.
in an arbitration with a sole arbitrator, if the parties fail to agree on the arbitrator within 30 days from the receipt of a request by one party from the other party to agree the appointment that shall be made on an application by the party in accordance with the provisions contained in subsection 4. Then
you proceed to the subsection 6 also.
Where under an appointment procedure agreed upon by the party fails to act as required under this procedure, or the parties or the two appointed arbitrators fail to reach an agreement expected of them under the procedure, or a person, including an institution, fails to perform any function entrusted to him or under the procedure, the appointment shall be made on an application by the party, by the arbitral institution designated by the Supreme Court. In case of an international commercial arbitration, or by the High Court in case of arbitrations other than the international commercial arbitration, as the case may be, to take necessary measures unless agreement on the appointment of procedure provides other means of securing the appointment. Here, my lord, I will submit where the High Court comes. The High Court, this section shall have, it's my submission, shall have to be read along with the definition. It cannot be separated. Here also the word "the" includes only that. My lords, in Calcutta High Court also, they have.
Mr. Bharti, that you are going a little far. I am telling you why. That this court has been defined for the different purposes differently. Right. You are referring to the 4 high courts. Even only the 3 high courts are the chartered high courts. Those have, from the very beginning, they are original civil. And after that, Delhi High Court has the original civil side. And to be very frank, this High Court has also got an original civil side. How I am telling you, when it is a testamentary interstate suit is tried, it becomes the original court. Between this will is property is in one state, will is executed in other state, there arises dispute. Where to go? Go to the High Court only. High Court has their jurisdiction under the Indian Succession Act. Right, it becomes this operation of and no, this is a special. This is you are going. Because this is a special provision, and this under section, Chief Justice doesn't pass any judicial order. Right? It is a quasi-administrative order he passed as a Chief Justice. This is very unique. The provision says the Chief Justice will pass, not the Court of the Chief Justice.
In 2015, the Honorable Supreme Court has dealt with it. The Honorable Supreme Court.
Yes.
I've got it here. AIR 2015 Supreme Court, Placiton A. The Arbitration and Conciliation Act 26, 1996. Now the present act also have the same section. It has not changed. Section 42, Section 2, 1E, Section 8, Section 11.
Yes.
Jurisdiction of the court. Application under Section 8 are made to judicial authorities, and application under Section 11 are made to the Chief Justice of the designated court, which is not a court as defined.
Yes.
Such applications would be outside the scope of Section 42. Section 42.
So this very judgment shows the enunciated that the Chief Justice will take, it is not a court. These are, you read that paragraph. This is not a court. That is why I'm telling the Chief Justice doesn't pass any judicial order. If the Chief Justice is empowered with passing the judicial order, it can have some traits of a court. They simply says without any comment that that person will adjudicate. Chief Justice only appointing a person to adjudicate the dispute. And this Section 8, Section 9 goes to the court. And these are the civil courts. Ever this High Court has dealt with this Section 8 or Section 9 petition?
My lord.
It is not under the order passed by the Chief Justice, is not an order passed under Section 8 or 9. It is under Section 11.
My lord, if I could sum it only for one sentence.
Yes.
The background is like this. The opposite party, number 1, files a petition under Section 8 in the court of the Learned District Judge.
Yes.
And gets some relief regarding bank transactions. Now he says that in that order, Justice M. Das, retired. Honorable Justice M. Das was appointed as an arbitrator. It's not a fact, was never appointed. Then the matter was kept pending. What has happened thereafter? The opposite party comes and moves before your lordships. That hints there has not been an appointment. Justice M. Das is not functioning arbitrator. We seek your lordships to intervene and appoint. That is how he has been appointed. My submission is, only I am reading one section. That Supreme Court judgment, and the matter has been, that is in 2015, and the matter has been referred to us for an authoritative pronouncement on Section 2(1)(e) and Section 42. It will be important to set out Section 2(1)(e) and Section 42 of the Arbitration Act 1996, which reads as follows. The court means, their lordships, the principal civil court of original jurisdiction in a district and includes the High Court in exercise of its original civil jurisdiction, having jurisdiction to decide the question forming the subject matter arbitration. Same has been subject matter issue, but doesn't include any civil court of the grade of such principal court. Then their lordships deal in para 12, as noted above, the definition of court of in Section 2(1)(e) is materially different from its predecessor contained in Section 2(c) of the 1940 Act. There are a variety of reasons as to why the Supreme Court cannot possibly consider to be a court within the meaning of Section 2(1)(e), even if it retains session over the arbitral proceedings. Firstly, as noted above, the definition is exhaustive and recognizes only one of the two possible courts. That court, unquote, for the purpose such as 21E, secondly, under the 1940 Act, the expression civil court has been held to be wide enough to improve.
So does Act 2015 Supreme Court, which page?
Minor. Act 2015 Supreme Court.
Give the name of the parties.
Parties.
The name of the parties.
Parties. State of West Bengal was associated contractors. That similar also is another
pages. Page ta kaun nahanti apana paduchanti, but you are not referring to citation, party name, something you are giving. You have started reading something without referring to any reference.
Page 260.
260.
It is because of my age. There is another case also. 3 cases I am giving. Year 2007, Supreme Court, 465.
15-1 is.
Then year 2012 Supreme Court, page 1280.
Number that you did.
No. Yeah. Of our own High Court. 2018 to ILR. Cutter 234.
Could you read paragraph 17 of the first report? State of West Bengal versus associate concept police. You read paragraph 17. The distinction is between section 42 and section 11. It is that. No, I have called out in this paragraph. There is 17 of the report of the
I don't want me to read the paragraph.
No, just you read yourself. That have you read it correctly?
Paragraph 17.
17 of this report. State of West Bengal versus associate. First is 13.
Yes.
The High Court also.
Yes.
If you download it from somewhere else, it is not original book of
original.
I can find there are 17. You just read from the just read it in your right hand side page. Yes, there are 17.
My lord, that the Chief Justice doesn't represent the High Court or the Supreme Court, as the case may be, is also clear from section 11. The Chief Justice may make such scheme as may deem appropriate for dealing with the matter entrusted by subsection 4 or subsection 5 or subsection 6 to him. The scheme referred to in this subsection is a scheme by which the Chief Justice may provide for the procedure to be followed in cases dealt with by him under section 11. This again shows that it is not the High Court or the Supreme Court rules that are to be followed, but a separate set of rules by the Chief Justice for the purpose of section 11. A, where the matters referred to in subsection 4, 5, 6, 7, 8, and 10 arise in an international commercial arbitration referring to Chief Justice, is those subsections shall be construed as a reference to the Chief Justice of India. B, where the matters referred to in subsection 4, 5, 6, 7, 8, and 10 arise in any other arbitration, the reference to the Chief Justice in those subsections shall be construed as a reference to the Chief Justice of the High Court within whose local limits the principal civil court referred to in clause E of subsection 1 of section 2 is situated, and where the High Court itself is the court referred to in the clause to the Chief Justice of the High Court. It is obvious that section 11(2)(b) was necessitated in order that it be clear that the Chief Justice of the High Court will only be sub-Chief Justice within whose local limit the principal civil court referred to in section 2(1)(e) is situated, and the Chief Justice of the High Court, which is referred to in inclusive part of the definition contained in section 2(1)(e). This subsection also doesn't in any manner make the Chief Justice or his designate a court for the purpose of section 42. Again, the decision of the Chief Justice or his designate not being the decision of the Supreme Court or the High Court, as the case may be, has no residential value, being a decision of a judicial authority which is not a court on record. Now, only I am emphasizing that here also the lordship referred to the definition of the word subsection 2.
They say that under this definition, it just is word that comes under section 11 will not be included. But again, this is a judgment in the perspective of the section 42 of the arbitration.
It was on section 42.
You see that the Chief Justice has been given power to frame a scheme because he is be guided by the not by the procedural rules. Because he is not a court.
Minor.
Yes.
Because your lordship know it was your lordship know that this is a case under section 42. By that way, they have defined, their lordships have defined section 2A. Similar view has also been taken in other two cases.
No, I will go beyond and confused. My approach to law is very simple. If I do not understand the statute, then I go to the external aid to understand the law.
Minor.
Otherwise, I will not go. It is very clear.
Minor. That's what
the word is this word Chief Justice.
Minor.
Doesn't say the court of the Chief Justice. It says only the Chief Justice. It doesn't say the High Court. Chief Justice is the person designated under section 11. He doesn't have any judicial power. He has the power of reference to the adjudicators or the arbitrators. Right? He doesn't also pass any judicial order under section 11. It is a mayor requires a administrative order to pass sitting under section 11, appoint someone as the arbitrator. There is no function of court under section 11.
In the instant case, what that happened, my lord?
Yes. What happens if simply someone dies?
No, it's not that way, my lord. When the initial appointment was made, it was made because a petition was filed before my lord saying that Justice M.M. Das did not act. That is why another arbitrator needs to be appointed. That is how this case came. There also it was objected to. That once he has gone over there.
No, but your challenge is that the Chief Justice doesn't have the power to pass this order. It was your challenge.
Yeah.
How that can happen? You are just arguing against a statutory provision. It creates a person, not the court, creates a person who will deal with all the matters. And just like a post office, you will say, go to that person, that person. He is not even given any opinion about the dispute also. in the procedure under section 11(6).
My lord, I challenge before my lord in a writ petition also. That was this. Here also, I came up in appeal before my lords. Only.
This is not an appeal.
No, I came in appeal. I filed an appeal challenging the decision. And my lords will plead to order that these are matters which could be raised at some point of time.
No, that depends. You know, we are in the most debating class, the lawyers and judges. Someone gives some opinion, and others will give the different opinion. But I am concerned with my opinion. Right? Section 11 is very clear. It's interesting to refer in that.
No.
If you say that, why not Mr. M.N. Das, why Mr. J.P. Das?
No. Very fair.
Reverse. Why everybody sort?
I'm
The jurisdiction is concerned, there should not be any confusion.
no, but my whole point of submission was regarding the jurisdiction. I submit on that. My only submission would be that probably which requests my lords, because I have scanned all cases. I have not found any direct. It requires my lord's intervention.
Don't worry, you will observe.
Now, my lord.
Sometimes what happens, if you go to the old decision,
Right.
there is always a possibility of getting confused. Because section 20, the earlier old Act, 1940 Act, section 20 was the section by which the matters were to be referred. And section 20, you know all that it was done by the civil court. Right. So that concept we cannot follow because the 1996 is a watershed difference has been created by this law. Unical provisions are all incorporated in our Act as well. 2015 amendment, a lot of things, and 2019 you see the lot of changes are being made in that. Because we are now living in a globalized trade in the world. So that is why that you have to look into the things in the how the act is being constructed, how the legal regime has been introduced. So the section 11 is a very special provision. Even as the chief justice is not a court, is a person that he is referring to the matters. He is not deciding anything, making no comments about the dispute. Only he searches for whether there is an existence of the agreement. The amendment section 6 came, right? Or there is an agreement in the clause in there of the arbitration in the clause. This is that, and that is what is the dispute has been recorded somewhere. Notice has been given to the opposite side. That's all the thing. He doesn't arbitrate or adjudicate anything. And this decision, paragraph 17, is clearly held. The Chief Justice of India, also not represent the Supreme Court. Chief Justice is referred in section that doesn't represent the High Court. Matter ends there. It's a subject matter for writing a very thought-provoking essay.
My lords, on that basis, if I could make a submission. It requires my lords.
To be very honest, I do not find any substance in your submission. Your submission is very far-fetched. Because the court, that is why the first reaction from the bench was that in section 11, the relevant section, you did not find the word court is appearing. Only you find the subsection 3A, they refer to the Supreme Court and the High Court for a different perspective of international arbitration.
No,
no, also for designating some in the center is an arbitration center. There are certain other things that come in now under section 11. But so far the reference is concerned, it is purely under section 4, 5, and 6. In the 3 subsections takes care of reference. So, Mr. Mohanty, in a better case, you raise the issues. Where is a matter relating to the section 8 and section 9, the definition of the civil court or court will be very material. In the event of the section 42, the designation of the courts will be very mechanical under section 2B, but not under section 4, 5, and 6. And this order has been barred under section 11(6) of the Arbitration and Conciliation Act.
That is why I was submitting it. I could repeat at the risk of repetition. Which needs my lord's observations or orders.
You don't usually pass any order to your meeting.
No, I'm not submitting. No, it is because of my anxiety, I'm submitting. Now, that is why I submitted.
Appreciating your anxiety. Now it is time to appreciate our anxiety. Every time we are discussing this petition. Senate Council, we basically
Moist dust.
District Administrator does by means of this petition plan of the order dated asking the company Mr. Mohanty Lalit Council. The definition of section the principal civil court of original jurisdiction in a district and includes the High Court in exercise of its ordinary civil jurisdiction, having jurisdiction to decide the question forming the subject matter of arbitration, if the same had been the subject matter of a suit, but doesn't include any civil court of a grade inferior to such principal civil court or any court of small causes, small two. In any case of international commercial arbitration, comma, the High Court in exercise of its ordinary civil jurisdiction, original civil jurisdiction, comma, having jurisdiction to decide questions forming the subject matter of the arbitration, if the same had been the subject matter of a suit, and in other cases, a High Court having the jurisdiction to hear the appeals from the decrees of the court subordinate to the High Court. Stop. Thereafter, the other definition has been provided under section 2, which are not very material for our present purpose. Stop. Mr. Mohanty Lalit Council made an endeavor to rely on a few decisions, but the most important but is reliance on State of West Bengal and others versus associated contractors. Polonia 2015 SC 260 has attracted our attention. In that case, the dispute arose from an application filed under Section 34 of 1996 Act. Under Section 34 of 1996 to set aside the arbitral award before the Principal Civil Court of the learned district judge at Jalpaiguri, West Bengal. Stop. The respondent to the said application challenged the maintainability of the said application under Article 226 of the Constitution, questioning the jurisdiction of the district judge at Jalpaiguri. The Calcutta High Court allowed that petition, holding that the said court of the district judge had the original civil jurisdiction, and as such, the application for setting aside the award, as application for setting aside of the award was excluded under Section 42 of the said Act, the court in its ordinary original civil jurisdiction is the only court which can entertain an application for setting aside the said award. Stop. Respondent in the writ petition. Earlier one respondent is coming, respondent in the writ petition. In para 9 of the said report, having referred to the section 2 within bracket 1E, it has been held by the apex court that it will be noticed that section 42 is almost the same terms as its predecessor section, except the words in any reference are substituted with wider expression, quote, with respect to an arbitration agreement, unquote. It will be also noticed that the expression, quote, has been made in a court competent to entertain it, unquote, is no longer there in section 42. These two changes are of some significance, as will be pointed out later, of some significance. Section 42 starts with a non-obstantive clause, which does away with anything which may be consistent with this section earlier in Part 1 of the Arbitration Act 1996 or any other law for time being enforced. The expression, quote, with respect to an arbitration agreement, unquote, widen the scope of section 42 to include all matters which directly or indirectly pertain to an arbitration agreement. The application made to the courts which are before, during, or after arbitral proceeding made under Part 1 of the Act are all covered by Section 42. But an essential ingredient of the section is that application under Part 1 must be made in a court. Stop. Having referred to this aspect, Mr. Mohanty has submitted that the application under Section 11 has also to be included for this purpose, and it can only be made to the court as defined under Section 2E of the 2 within bracket 1 within bracket small e of the Arbitration and Conciliation Act. Stop. Mr. Mohanty has also taken us to part of the para 12 where the apex court has observed that we respectfully agree, but for reason that such applications are made before the judicial authorities are not courts as defined. Also, a party who applies under Section 8 doesn't apply as dominus litis, but has to go wherever the action may have been filed. Thus, an application under Section 8 is parasitical in nature. It has to be filed only before the judicial authority, before whom a proceeding is filed by someone else. Further, the judicial authority may or may not be a court, and a court before which an action may be brought may not be a principal civil court of original jurisdiction or a high court exercising original jurisdiction. Stop. Dilating further and to narrow down the definitional aspect, the apex court has observed in para 17, the observed as follows, para 17, that the Chief Justice doesn't represent the High Court or Supreme Court, as the case may be, is also clear from Section 11. Quote, the Chief Justice may make such a scheme as he may deem appropriate for dealing with matters entrusted by subsection 4 or subsection 5 or subsection 6 to him. Unquote. The scheme referred to in this subsection is a scheme by which Chief Justice may provide for the procedure to be followed in cases dealt with by him under Section 11. This again shows that it is not at the High Court or the Supreme Court rules that are to be followed by a separate set of rules made by the Chief Justice for the purpose of Section 11. Stop. Subsection 12 of Section 11 reads as follows. Quote A, where the matters referred to, subsection 4, 5, 6, 7, 8, and 10 arise in an international commercial arbitration, the reference to the Chief Justice in those subsections shall be construed as a reference to the Chief Justice of India. B, where the matters referred to in subsection 4, in bracket 4, 5, 6, 7, 8, and 10 arise in any other arbitration, the reference to Chief Justice in those subsections shall be construed as reference to the Chief Justice of the High Court, within whose local limits the principal civil courts referred to in clause within first bracket E and subsection 1 of Section 2 is situated, and where the High Court itself is the court referred to in that clause to the Chief Justice of that High Court. Having argued strenuously, Mr. Mohanty and his senior counsel has questioned the jurisdiction of the Chief Justice to pass an order of reference Such is the impugned order dated 39/20/22. Stop. On the basis of a fact special to this proceeding, Mr. Mohanty has submitted that a reference was made when an order was passed under Section 8 of the Arbitration and Conciliation Act to another retired judge of this High Court. Stop. But we do not find any material to come to a definite conclusion that any other retired judge was appointed as the arbitrator by the competent authority. Stop. It appears from the order dated 3/39/2020 that due to the said demise of Justice D.P. Mahapatra, the former judge of the Supreme Court, the court appointed Mr. J.P. Das, a former judge of this court, as the sole arbitrator in place of Justice D.P. Mahapatra to adjudicate the dispute between the parties. We have no confusion at all. This order has been passed under Section 11(6) within Article 6 of the Arbitration and Conciliation Act, and this has not been passed by any court, but the Chief Justice. So, as it has been categorically held that the Chief Justice is not a court, but a person designated by the Arbitration and Conciliation Act. In State of West Bengal versus Associated Contractors, the Apex Court has clearly laid down that law. Having observed this, we do not find any infirmity in the order is challenged by the petitioner. Accordingly, the writ petition stands dismissed.
Item 5. Well, at the appearance, we are for UP number 4, the state UP number 3. Appearance of been noted, we are spoken about.
So one thing that we have not examined, the issue of the jurisdiction of this court to judicially review the order passed by the Chief Justice in exercise of his power conferred under Section 11 within Article 6 of the Arbitration and Conciliation Act. No, this is not challenging yet. In a writ petition, how can we challenge the writ of the writ for that is one is that order that we have said is okay. 2 and 3, what are the 2 and 3? Who is the application? Also, we do not find any merit in the challenge against the order dated 15/9/2016, passed in ARVP number 5 of 2000. No, it is not. 15, Annexure 2 to the petition, and the order dated 4/5/2023, passed in WA number 670/2021. Annexure 3 to the petition. All right. Next.
Item 5. Item number 9, my lord.
Item number 9, you have that lordship directed.
Page number 3. Already take the item number 9 first. Let us see.
Yes, of course.
I don't think, Mr. Udgata, anything can be done today.
Small matter.
Let us see.
Item 9.
Item 9, my lord, I am for the respondent. I seek some urgent and Mr. Nayak is out of state.
There is a personal pain.
Personal difficulties.
Was in court number 10.
Prepared urgent.
It's been avoiding all through, my lord.
No.
A writ appeal copy was offered. He said that the client has taken away the bill. So that's where notice was issued. Today I have been calling him. 2 days back also, he is not picking up the call, send messages and looked around for all over.
There's some personal.
Yes, some personal. Ultimately find him. Half an hour before.
Today he has some personal difficulty. My lord, urgent this matter 2 weeks after.
Out of station, personal difficulty, all these things. And at court number 10, you were there, doing all the cases throughout the day.
Prepare personal difficulties. There are some personal difficulties. Entry notice is their favor.
Last time it was not extended. Inadvertently that mentioned it was but the interim order was extended last occasion.
We have no objection to extend the interim order.
Tomorrow, my lord, tomorrow, but this is very urgent matter. This is very urgent. Only thing, conciliation proceeding has to be done, and whether the cost would be imposed in the facts and circumstances of the case. Only thing that is the truth.
But interim order is their favor. Also, 12th
the conciliation proceeding is mandatory, so that is to whether it is to be done or not, or whether the cost to be imposed in the facts and circumstances of the case. That is the only thing, my lord. A student, my lord, the appellant wife is a student. 25 tomorrow.
Let us see.
My lord,
tomorrow it will come.
Next week, any day, time.
No, we are fixing it to tomorrow. Then let us see tomorrow what happens. We will not allow someone to avoid the courtroom, and that cannot be the ground of adjournment. He expects some ethical conduct from the counsel also. He is categorically making a statement. He is found arguing a matter in court number 10. Who is the counsel?
He is a PK9. And all his associated have been informed throughout.
You just informed that he should appear tomorrow on the court.
Obliged.
Yes.
Item 5.
Obliged.
There is an interim application for condonation of delay. The IR number 4876 of 2023 and another interim application for dispensing with the filing of certified copy.
Filing of certified copy.
My lord.
First take 4878. There is an application for dispensing with the filing of the certified copy of the appeal order dated 29/7/2020. Asking WPC OSC number 1061 of
2013. 2013.
2013. Mr. M.K. Kuntil and additional government editors submitted that the filing was urgent. The certificate copy could not be obtained. Instead, a downloaded copy of the said order has been filed with the memorandum of appeal with this application. We do not find any impediment in allowing the dispensation, but such dispensation is subject to filing of the certified copy within a month from today. Accordingly, this application is allowed. Next is 4876 of 2023. Heard Mr. M.K. Kuntil and counsel appearing to the petitioner. This is an application under Section 5 of the Limitation Act for condoning the delay of
300 days.
340 days in preparing the court appeal, challenging the judgment in order dated 29 July 2022, passed in WPOEC number 1061 of 2013. Issue notice as to why the aforementioned delay shall not be condoned or any other order shall not be passed as deemed fit and appropriate in the circumstances of the case. Notice is made returnable on 13th of November. 13th of November. Steps for service of notice on the opposite party. I think one will do. Well, opposite party number one will be taken within 3 working days from today.
Item number 6. Item 6 is similar to item 7. So it may be taken up as last case. Item 6, that is rehabilitation, that is similar to item 7. It may be taken up as last case.
Item number 7.
Item 7, I have filed 5 writ appeals. That is, first item is at sub item number 3, writ appeal 808. Then next is
810.
808 of 2021. Sub item number 3. Then another is sub item number 10. Writ appeal 926 of 2021. 2021. 926 of 2021. Then sub item 20. Writ appeal 58 of 2022. Yes. Sub item 21. Writ appeal 59 of 2022. And last one is sub item 22. Writ appeal 60 of 2022. Yes. My lord may take up this matter first.
But I have a query from you, just Mr. Kunti. I asked you that in which cases you agree that is covered by our judgment.
Yes, for that I have prepared a list.
Give a copy to the council of the other side.
Supply.
I have supplied them on through WhatsApp.
Supply, madam. We have received the same.
I have supplied some of them hard copies and some. I inspect what is
Some also blank, my lord. That 508 nothing else. CNC, for example, CNC. They said state is not party, so we are not right now here. In this,
But I have met state.
State is party, my lord.
How is agreed by our state party knowledge, sir, you may not be agreed actually. But I am going to tell you, ଆପଣ ତ ତାହେଲେ କିଛି ତାଙ୍କର କିଛି କହିବାର ନାହିଁ ସେ କହୁଛନ୍ତି. Nothing to say where his state is not a respondent. So that what how can state to
judgment?
Yes, my lord.
Copy of the judgment.
Yes, I have copy of the judgment. As felt from my lord, Chief Justice, you have not mentioned which is covered. In fact, or you can tell it now by Cyrillic so that I can pick it.
In fact, what has happened? I have gone through my lord's judgment, and in this number of cases, only few cases will be covered. But in the number of cases, there is delay in filing application, and all the cases have been disposed of at the first admission stage without giving us an opportunity to file a counter. I am giving an example. Suppose one died in 2016. His legal heir has applied in 2019. So as for the rule, he had to apply within 1 year. Their counter is necessary to controvert their pleadings. We have not been given opportunity in all those cases. And all
Already in my case, my lord, I have filed within 6 months. 5 months.
I don't think that I have said in some cases, not in all cases.
He says that where they was there for 3 years, they do not know what has happened. because they could not get obtain our instruction, and but the matter has been disposed of. And in some matters, I have gone through my lord's judgment where a lordship in division bench has said that to consider their case in accordance with that 90 rules who have
that is what
I'm submitting. But in some cases, direction has been given to give them appointment.
Yes.
So we have to examine their case on 90 rules. If they will fall under that 90, even if
obviously that is what we are exactly whether these year 2020.
I am not 2020. Even if they fall under 90 rule, court cannot direct to give them appointment.
We are not given that.
That I am saying my lord's direction is to consider. That I am saying. Consider in the light of the judgment. Consider in the light of the judgment.
That has to be ready to consider the appointment.
Yes,
but that consideration doesn't mean that just because if you come within the parameters of this,
yes,
it becomes a mandate of the court. Yes, scrutinize whether they come up with these parameters. The aspect of the delay is also a part of the consideration whether they come within the scheme or not.
But all these things have been clarified in Malayalam city case, my lord.
Yes.
Appointment for consideration. In the meantime, 20 rule came into force. They again
decided that we have decided this.
Application. In that case, they have
in one case of someone has filed this fresh application. We said the filing will not mean because he has filed a proper application under the old rule.
Yes.
The case will be considered under the old rule.
Suggest one thing.
Minors have passed.
Suggest one thing. Suggest one thing. But in all these cases, including item number 1, Bindu Sagar case, please, Bindu Sagar, issue is saying, yes, but the issue is same. But there are issues. In Bindu Sagar case, which rule will be applicable? Whether 1990 rules or 2020 rules? That is answered by the Honorable Single Judge that since date took place and application was made much prior to coming into force of 2020 rules, 90 rules will be made applicable. That has been answered. Second question is, because his father was a block grant employee, whether block grant employees or block grant schools will be treated as an aided educational institution or not within the meaning of section 3B, that has been answered by your lordships. So both the issues. Now, your lordship sitting in division bench in other case where virus were challenged, your lordship have answered both the points. So, Bindu Sagar case is squarely covered by your lordship judgment. What my learned friend is saying that is not covered, that is not correct.
Mr. Khuntia,
Mr. Swai, he being the appellant there. He has a right to address. He has a right to address. I am also not disputing that. My lord is not asking, disputing that. In fact, he is not arguing that. So why we are joining issue there? Bindu Sagar, you vote for Bindu Sagar. Bindu Sagar, why it is myself? Why it will be segregated? Myself. We are asking that only.
I am telling you that this judgment is there basically on which rule will apply and in what manner. Right, and we have seen that whether the rule, the persons who have applied, they come within the scheme according to the rule or not. We said you consider where there is some confusion, something about them, such as delay After 3 years, one application has been filed.
Yes, my lord.
Yes,
That is, you can consider because the outer limit is 1 year.
Yes, my lord. Outer limit is 1 year.
And if someone finds aggrieved thereafter,
Yes,
they may come again. We'll decide.
My lord, so far as my case is concerned.
Yes,
Yes, member.
So, Mr. Kuntia, you got the proposition.
Because so far my understanding and Mr. Kuntia that all the petitioner were presently had to go to 5 before new rule came into operation.
Yes.
Pilots have relied upon Molayana case. Other two judgment dealing with the self-same aspect and a different view has been taken by considering that view has not been taken into consideration.
Yes.
Place those two judgments only.
All right.
And those judgments. Yes, yes.
All right.
My lord, I'm pleased, my lord. The chat given by my learned friend.
Your point is well taken that he has not said which is covered because that was the query of the court.
Yes.
He may replace that chat or update that chat. But now Mr. Muduli is referring to only those 5 judgments. Where I think you are only appearing for OMC.
He is appearing.
And also,
Learned counsel appearing in this matter.
for accepting this judgment, you have given one very unique reason in the judgment. That why we are going to Molayana's judgment because this goes from this way. Right? Because we do not know what the scheme is all about.
89.
There is one of the handicap of the
Pilots have read down rule 6(9) and relying upon Molayana city's case. Only that is the finding of the minor. That
when you are saying Molayana Sethi's case in Apex Court or in High Court? Because Apex Court,
yes,
other 2 judgments are Apex Court.
Yes, Apex Court.
So that has originated from this court.
No.
So then that is the question my lord is asking you.
That Molayana
Sethi from this court.
Molayana city's
So in this judgment, Mr. Earlier
differing judgment.
Suchitra lady, Suchitra. So in that judgment, Molayana Sethi has been relied upon because that has emanated from this and those rules have been interpreted or deliberated upon.
So here, in Molayana Sethi's case, no rule has been interpreted. Keeping in view the particular facts and circumstances of that case,
they have made my lord,
Molayana Sethi's observation. Yes.
The other reference of Supreme Court, you are referring to the subsequent judgment by Justice Emerson.
One by Justice Emerson.
That is on it.
Only one by Justice Krishna Murari and Justice D.B. Nagarat. And the other one is Justice Emerson and Justice.
So Justice Emerson has again Justice Emerson another, so that he's again referring. That
Read those 2 judgments.
I could put him on the
My lord, may kindly see this state of West Bengal versus Debabrata Tiwari, paragraph. Paragraph 7, my lord, may kindly see the heading. Policy Well, I am listening from the live law judgment.
Paragraph.
Yes, yes, wait.
Paragraph 7.
The first line, so that we can easily get it.
The present appeals have been filed assailing the judgment and common order of the High Court of Calcutta dated 30th September 2019 in a batch of appeals being mat number so with CAN number so and connected matters. By the improved judgment and common order that is
SEC online.
I have also given the 2006
SEC online. Because at times some Mr. Mohanty was reading some document. It was not there.
The present appeals have been filed assailing the judgment and common order.
Kindly wait. Present appeal has been filed.
Yes. Appeals have been filed assailing the judgment and common order of the High Court of Calcutta dated 30th September 2019 in a batch of appeals being made number so with CAN number and connected matters. By the improved judgment and common order, the division bench of the High Court set aside the order of the single judge of the High Court dated July 2018 filed the and connected matters and directed the director of local bodies, Bodhgan municipality and the concerned authority in Ranaghat and Habra municipalities to consider the application made by the respondents if petitioner seeking appointment on compassionate grounds.
Mr. Mudali comes straight to paragraph 60. Yeah, the court itself has stipulated what is their decision.
It was further submitted that that is the submission.
No. There are 60, not 16. 60 oppositional case.
In file, the present appeals succeed. Appeals succeed. Last page of SEC, or you are referring to live law?
Yes. Well, there are in fact two issues you are trying. This finding is in respect of second finding.
First, two issues have been addressed here also. Just read. I do not know. The paragraph starts with in fine the present appeal.
The present appeal succeeds on two counts. First, there was no policy existing to govern compassionate appointment to post under local authorities in the state of West Bengal, and hence in the absence of such a policy, compassionate appointment cannot be granted. Second, assuming there was such a policy, it would be of no redeeming purpose to direct that the application for appointment on compassionate grounds be considered and decided several years after they were filed. Well, this second portion we are happy.
That is already observed in this case also.
No, there are other findings that I am placing in this judgment.
No, that are the discussion.
No, finding I am placing.
Yes, please. This is a 57 also, there is a finding. The same thing has been called out in 60.
Paragraph 41.
This is like we are dealing with certain employment circular.
No, not circular. Applying the said ratio 4:1. Applying the said ratio to the facts of the present case, we hold that the respondent read petitioners upon submitting their applications in the year 2006-5 did nothing further to pursue the matter till the year 2015, that is for a period of 10 years. Notwithstanding the tardy approach of the authorities of the appellant state in dealing with their applications, the respondent read petitioner delayed approaching the High Court, seeking a writ in the nature of mandamus against the authorities of the state. In fact, such a prolonged delay in approaching the High Court may even be regarded as a waiver of remedy as discernible by the conduct of the respondent writ petitioners. Such a delay would disentitle the respondent writ petitioners to the discretionary relief under Article 226 of the Constitution. Further, the order of the High Court dated 17 March 2015, whereby the writ petition filed by some of the respondent disposed of with a direction to the director of local bodies government to take a decision as to the appointment of the cannot be considered to have the effect of revival of the cause of action. Then paragraph 42, Malayananda Sethi has been taken note of.
This 41 also, yes. Malayananda Sethi has given the reason.
Yes, 43.
No, these reasons we may not accept it in view of the Indo Watch Company's judgment. That's why if the two equal benches judgment are coming in conflict, it is up to the particular court which reason they will accept.
Later judgment will prevail.
No, sorry, 2005 decision is no more valid decision. You are referring to 2005 Supreme Court. The later judgment will prevail.
And this has been taken note of.
Now it's all through the consistent rule. Judgment will prevail.
Well, had Malayananda Sethi not been taken into consideration, then in that event,
We are not that. Regarding the opinion, suppose I filed an application in the government department, and an application is completely full in all respects, and the government sits over it. It's my fault.
Yes.
This proposition is that why I not pursued the 10 years? Why is a citizen can pursue a government office?
Yes. Applied in 2011, will consider.
No, we are trying to pursue you as the government.
No, this is otherwise.
We are doing the thing. We are pursuing the government. Look at the distress of the families. They are fighting here for 10 years, 12 years, and now they will be guilty. That why you are fighting 10 years? Why? What can they do? They can take up arms and go to the secretariat. Let's give us a simple answer. If this observation is made, what shall after?
Answer is in this judgment.
What is the answer?
The next paragraph.
Yes, read.
Paragraph 43.
Yes.
In the said case, in the said case, the claim of the applicant therein for compassionate appointment was directed by this court to be considered by the competent authority. Well, this is with reference to Malayananda Sethi.
And then just read the letter parts, few lines, that will get my point.
Yes, this court noted in the said case there was no lapse on the part of the applicant therein in diligently pursuing the matter. The delay in considering the application of the appellant therein was held to be solely attributable to the authorities of the state, and no part of it was occasioned by the applicant. Further, in the said case, the applicant was prejudiced not only because of the prolonged delay in considering his application, but also by the fact that in the interim, the policy of the state government compassionate appointment had changed to his detriment. Therefore, the facts of the said case were distinct from the facts.
So the Malayananda is not discarded. It says the fact of the Malayananda's case is very distinct from the present case. So what is the observation has been made in the present case, except para 60, there is no other observation.
In the present case, the conduct of the respondent petitioners cannot be said to be blameless in that they did not pursue their matter with sufficient diligence. However, the observations made in the said case as to the manner in which application for compassionate appointment are to be considered and disposed of are relevant to the present case. As noted in the said case, the operation of a policy scheme for compassionate appointment is founded on consideration of immediacy. A sense of immediacy is called for not only in the manner in which applications are processed by the concerned authorities, but also in the
Mr. Muduli, I can give you the better judgment for this purpose. Filing the application in a belated stage, 2017 Justice T.S. Thakur judgment. This is more distinct that says no, the government doesn't have any obligations to consider those appointments when someone files an application 7 years after the death. It says that this urgency of supporting the family evaporates by the lapse of time. So such cases, no court is directed by government.
Well, here in some of the cases, out of 5 cases, probably two cases.
No, perhaps you have not got, because maybe all of them are speaking, that whether that consideration also includes the delay part, whether after a certain delay you will consider.
Yes.
Because as
ultimately forget about this effect of these subsequent or the previous rules.
Yes.
Ultimately, this case has to become within the 4 corners of the scheme. That is the basic, that is why I was referring to this paragraph 60. Right? These 2 aspects have been taken care of. You are the government, you are not the ordinary citizen. You are the king and citizens are lamb.
Model employer. In your model employer, they are experts.
So what we have given this a certain direction. I think all the cases are covered, but we are giving you some leeway that which is covered, you employ them. But the basic consideration where you are just holding back those things, that no, the date of death has no value, only the date when you will consider. It is maybe after 7 years, after 8 years, 9 years. That cannot be the date according to the opinion. And Maulana has supported this case. And all reasonable men support this.
Contrary to N. Santosh.
No, Santosh has also referred to the Rajya bench now.
Has also dealt.
No, taken care of. No, the reference order, if my lord see, that has been referred to a 3-judge bench.
That is when the 3-judge bench will defer. Now this 5-judge bench.
Santosh is 3-judge bench judgment.
Right. That is why I'm telling you the strategy is that let the 3-judge bench also defer. 5-judge bench.
Now, who is doubting the correctness of N. Santosh and refer to 3-judge? If 3-judge they doubt or agree with N. Santosh, then 2-judge will not prevail. N. Santosh attains finality. They may refer it to 5-judge.
If there is
That is what my lord is saying.
Even a single judge can question the Rajya bench decision. Yes, there is no legal bar. He may seek the review of your own decision. Law of precedent is there, but law of dominus litis is also there in our common law jurisprudence. So, I think Mr. Kunti, I was very hopeful that you will be preparing.
I am submitting those cases which are covered and which are not to be covered. So I have given that list. If your lordship will mark.
First of all, you make a very bland statement.
Yes, ma'am.
Whether all these applications were filed before the new rule came or not.
No, some cases, so they have filed application after 2020 rule.
Okay, for the first time, or they had filed earlier.
No, for the first time the cases.
Please point out that.
I have given that in that I can point out. That's
only those cases you point out. And whether you applied the principles related to or enunciated in the city. You can reconsider that. It is only direction for consideration. Yes, even those cases where after 2022 rule,
and we have considered that we do not direct any authority to give appointment. Only in case
that I have seen my lord's judgment is to consider. I am holding that my lord's judgment. Last part.
Consider one.
Why they are offending? Why will you reject?
Past conduct, they are
the second part is important. Because then you challenge that after rejection.
Yes. They have to. I am reading my lord's judgment, which you are relying, that I am relying that judgment. I am giving my
senior counsel matter in this set from summer in this matter, the death is mentioned right to matter, but the date of application is mentioned wrongly. That is 13/1/2020.
And you never say that it is covered. So please wait.
Not allow you to
by giving a prescriptive parameter, you are writing your
Let him pay. My
paragraph is 85 of the that effect while dealing the application if the petitioners have sought for the rehabilitation appointment GIA includes that the government or the applicable rehabilitation in those instances will be separately determined by the on the basis of policy of the government and discussed by us. It is found that the Odisha civil rules
Just don't interrupt. Just speak to the microphone. Maybe the noise is
was applicable on the date of death of a deceased employee, the petitioner shall be considered for rehabilitation assistance as appointment. So far as retrospective operation of rehabilitation assistance appointment is concerned, this court cannot direct the appointed party to give the appointment retrospective under the rehabilitation appointment scheme as much as it is no more res integra. The petitioner does not have any vested right of appointment under such rehabilitation assistance appointment scheme. They are only entitled to be considered under the scheme for that purpose. That was my last direction. They will be considered.
Yes, yes. Related to retrospective appointment. Appointment cannot be given by any court. Cannot
be. Consequently, the approach party shall consider the application of the petitioner under the Odisha Civil Rehabilitation Rules, read with the relevant policy extending such scheme to the government at the relevant time of death of the deceased employee for the purpose of within the time as prescribed. As I read from my lords, that your lordship had directed to consider their case. But in some cases that I am giving that example, that your lordship may see my chart.
No, what? The single bench judgment?
Yes, my lord.
That will be interfered with.
Yes, but that I am giving that those cases which will be covered by my lord's judgment. This
Mr. Khunte, I think perhaps they are also happy that they will be considered by the earlier rule. Yes, sir, because you are challenging that decision. Challenging that line. I guess that I am very seriously saying that I am
those cases where direction has been given to appoint them as per their qualification.
Will they interfering with that?
Yes, madam.
That decision will be that this eclipse that direction. If you want also the express direction, that also will provide.
That will be covered by my lord's direction. What my lord has directed in those cases, that will consider their case.
Yes. So 85, yes, Mr. Yeah. Why 85 express? You have the Chief Justice. 85 eclipses the Honorable Single Judge's order judgment.
No, that
they accept that.
Yes, ma'am.
That.
I have been pardoned, my lord.
Yeah, let me complete. Then,
Mr. Patnaik, just kindly wait. Your learned colleagues are there. So many of them in court. Please wait.
Let me complete.
Yes.
I am giving those numbers, those which will be covered by my lord's judgment. And
you think that all the conditions are covered?
No, my lord.
In your mind, then all the petitions you will be relook into this. You do not discard it at this stage.
Yes, madam.
It is we are living with you. We are not giving the direction to appoint them.
Yes, ma'am. But in first case, what has happened? Why and
Mr. Khunte, I kindly appreciate it. The contribution will be reconsideration also.
In first case, what has happened?
No, before insisting, before submitting that, we will not consider him.
No,
that opposition will accept.
Sorry.
In the first considering direction was not given some consideration.
Not considered again. In first case, we have recalled our policy decision. That has been set aside.
This case, we are giving certain that in this decision also, you are given some the broader the facets of the thing how we'll consider.
Yes, ma'am.
Then what is your problem?
In first case, why I am saying those who are block grant employees, those 5 cases are to be segregated from all these cases.
What we have observed, yes, you are also to consider under the present scheme, or whether you have extended that scheme for the block grant or other these persons who are working in the aid school.
First, what has happened? We have extended that benefit.
Mr. Khunte, just make this thing simpler. We have not made the declaration.
What in first case, what is the problem with Osmala that I am saying? In first case, we have extended the rehabilitation assistance scheme to the aided educational employees. Subsequently, that has been withdrawn in respect of block grant employees. That this is a policy decision. And that has been quashed by Honorable Single Judge. So that I am submitting, that matter may be segregated from all these cases. And
all right.
810. That I am submitting, that 810 may be segregated and your lordship may fix it to tomorrow for hearing.
And yes. Yes, yes. Policy of the government, my lord. So far as block grant employees are concerned, my lord, in Bimbusagar's case, his lordship has held, relying upon the GA Department Circular of 1998, that GA Department is the competent authority under the OCS rules to extend appointment to the areas of the employees of aided institutions. And aided educational institution, that is Section 3B defines aided educational institution of the Orissa Education Act, that has also been dealt with. And so far as the circulars issued by the School and Mass Education Department, government itself considered that the school and mass education department has no jurisdiction to issue any circular overriding the GA department circular. So therefore the GA department circular survived, and since GA department circular has not yet been withdrawn till 2020 rules came into force, GA department circular governs the fields till 2020, and in 2020 rules, but there is no scope for the employees of aided educational institution. Only government employees are entitled to get the benefit of rehabilitation. So therefore, that portion has been dealt with. It is not a case.
Sorry, that para 86 doesn't refer to block grant.
No, it refers to aided institutions.
Exactly.
It refers to aided institution.
So maybe the same judgment will result after you argue Bindusagar.
Because in return,
we are relying on this particular Suchitra.
Yes.
To buttress your submission in Bindusagar. In Asil.
But in Ritanjali Giri's case,
so how many block grant cases are here in this list?
5 to 6.
So now, right now, since we are going to arrive at that apart from those 5 and 6, which are covered first, you say?
Yes, that I am saying that which are covered. You will also may submit.
Your point is well taken, Mr. Soil. That in view of Suchitra, single judgment,
yes,
is also. I mean, if you apply Suchitra, yes, that judgment cannot be interfered with, but only to the extent, consideration. Consider also block grant in this
case, which has been taken note of in Suchitra Abba's case. Well, in Ritanjali Giri's case, the single judge has held. There is no distinction between block grant.
You just wait so that can be pronounced, but you have to make that submission.
But yes, Kuntia, I find there is a strength because usually these things, according to the rules of business, it is the GA and PNT, they have the authority to issue circular.
Yes, ma'am.
So we'll observe that their circular will prevail.
Yes, ma'am. That has been dealt with. If GA department circular will prevail, then we have no.
That is your what is submitting.
Yes, yes. Right. Ma'am, what has happened, my lord, that notification which we have recalled is
GAPNT.
Look, the education department has recalled their own circular. That has been set aside. If GA department circular will prevail, then we have no objection.
This matter ends there?
Yes, yes, matter ends. That is since 1990.
There will be one more
some cases which are not numbers. Lot of cases which are not covered by my laws, that because they have applied it.
Those applications were filed after the new rules come for the first time. Yes, their application will be straightway rejected.
Yes, but that I am giving them those numbers.
The numbers are not, you are observing.
Yes, madam. Yes, madam. That will cover my.
That's wrongly stated, madam. They are
Now, so you have filed the application before 2020 rules. That will be covered. The judgment will cover it. Yes, that those who have filed for the first time under the old rules, but after coming up with the 2020 rules, that will be straightway rejected.
Yes, my lord. That will be riders because the rule prescribes limitation of 1 year.
That is there.
That
is there.
So your lordship have rightly hold.
No, Mr. Mahant, I don't know. You have invited this order. Observation of my lord.
A limitation of what?
Those applications are pending. This is in between application. Yes. He's stated in the chat. He's also trained.
Chat.
Yes, they have asked to submit. Sir, two or three applications in consideration. No, the judgment is very clear. Suchitra is very clear. So why are spoiling others' case? You give it in writing. Both of you agree that matter to be detached. And for a separate, you are challenging on whether ground of rejection when mother is available, but that is covered by Urvashi mallet. So you Ajit Bari case mallet or Urvashi is also there. Yes, by justice. So please give that separate case. That judgment will also be pronounced. That is following the process here. That is the 9th. He also says that is separate. So give it in writing in a paper.
My father was working in Cuttack municipality, but the council is absent from the day one.
Their council, man.
She had to ride with Mr. Naik.
That is maybe dismissed for different.
What is the judgment? No, this is not this one. What is the OG? There's no pregnancy today. What is your case that we are taking your case? You argue some before some other bench.
My case, that case is different, my lord, because that is 2B. What has happened in that case? That instead of his mother, his son has applied, so we have rejected his case.
But we give to the mother.
But his son has applied.
You should change it.
That person seems to be affected. He will be affected, so if he is to that proposal, we have no objection. My lord, I even that decision also in my written note.
Give the written note.
939 of 939 of 21.
Mr. Mishra. Which page, sir?
List of
Again? Page 3.
Oh, it is.
Your lordship, in order that your lordship.
In order, that is 939 of 21.
It is sub-item 12. No, because no sub-item is visible here, so it becomes difficult. Better to go by the page.
Your lordship, order dated 14/11/2022. That is order.
What is the order? All the appeals are by the state. All the appeals are by state. Yes. Here for the mining corporation. Mining corporation is also state. State undertaking.
There, Mr. Mudali,
You just give the list where you are appearing, state council, you are almost only
all cases where state is the party, I am appearing.
always, huh? Right, name is name. And Madhuri is appearing. This matter is appearing to be. Please, the council's name will provide, because who is appearing for the respondent petitioner.
That is available in the list for each judge.
But there may be so many.
We know that it is available in the list.
In the number 73 or first case, I am appearing. Case one.
Just mark me कर दे pencil there, so that it will be easier for him to look at the file. Just have to list of copy matter. The grounds in this I don't take it. Just please be quiet so that lordship can dictate the orders. There's some difficulty. The class have that advantage. And Mr. P.K. Muduli, learned counsel, who is appearing for the Orissa Mining Corporation Limited. As asserted that some of the impugned orders has given a direction straight away to appoint the petitioner respondent under the
Under the scheme is available in Orissa Civil Services Rehabilitation Assistance Rules 1990. It has been also stated that on introduction of Odisha Civil Services Rehabilitation Assistance Rules 2020, in short, the new rules, all the pending applications will be considered only under the new rules. But the council has submitted that on assumptions that the Odisha Civil Services Rehabilitation Assistance Rules 1990 is extended to all the government aided schools or the block grant schools / colleges. The direction has been passed. Even one order issued by the secretary, whose order has been set aside.
In some cases, in Bindu, Secretary School and Mass Education, that is 2019 circular.
In this batch of cases, in case secretary's order has been set aside by the Honorable Civil Judge.
In some cases, not set aside.
Circular dated?
Circular dated 1/8/2019.
1/8/2019, issued by the Secretary, School and Mass Education Department, has been set aside. So by that circular, the Secretary School and Mass Education Department had recalled the order extending the benefits of Odisha Civil Services Rehabilitation Assistance Rules 1990. Stop. It may be noted that according to the rules of business,
G Department circular is 14/10/1998.
The general administration, personal training is a part of this department.
General Administration Department, GA. General Administration Department.
GA
and PG. Personal
GA and PG department had issued a notice, issues the notification dated
14/10/98.
14/10/98.
Extending the benefit to the aided institution.
Extending the benefits of the rehabilitation assistance to the aided school, not the block grant.
Yes, my lord. It includes block grant. Not include block. Yes, that did. We are not extending the benefit of the block grant. That has been interpreted. Only and the state.
What is the name of the council?
That has been interpreted.
Mr. K.K. Swain.
That we have challenged that.
Learned counsel appearing for the petitioner in your petition number is?
My lord, that is the first case. WA number 810 of 2021. 810 of 2021.
Has stated that in that circular, block grant institutions are also included.
No, my lord, no, that was not that. We have included in
submission, sir.
Yes, sorry, my lord.
Mr. Swain, submission.
Yes, my lord. Sorry, my lord.
You are not Ukraine, you are not Russia.
Sorry, government also consider
like that.
Government also consider Bindusagar. That
no, Bindusagar judgment is under challenge.
Yes.
Stop.
And that ground they have not taken.
All right. Stop.
It has been stated by Mr. Khuntia and Mr. Muduli that in some of the writ petition, the petitioner has approached the competent authority for appointment under the rehabilitation assistant rules even after the new rule was introduced. Stop. The rule is apparent on the face of such action. However, the fundamental question that has been raised in all these appeals that the rehabilitation assistance shall be guided by the scheme as framed by the government and by the scheme alone. The courts shall be loath in interfering with this, the affairs of compassionate appointments. Mr. Khuntia Learned Counsel has further submitted that the learned single judge in some of the petitions has given the direction to appoint the petitioner whose application was filed after expiring of the period of limitation, i.e. 1 year from the date of agency. Those are apparently powers and requires interference from the court. Mr. Khuntia has also stated that there cannot be any retrospective appointment. And finally, Mr. Khuntia has submitted that it has been well settled by now that the right to get appointment under the rehabilitation scheme is not a matter of right, but is matter exclusively relatable to the government policy, and the consideration should be made within the four corners of that policy only. Mr. P.K. Mudoli, Learned Counsel, has quoted a unique submission by relying a decision of this apex court in State of West Bengal versus Debabrata Theory and others, colon 2023 SSC Online SC 219. In the decision, apex court having relied on Malayananda Sethi versus State of Orissa, colon AIR 2022 SC 2863, 2836, it was held that the basic policy is immediacy in rendering financial assistance to the family of the deceased consequent upon his untimely death, the authorities must consider and decide such application for appointment on compassionate grounds as per the policy prevalent at the earliest, but not beyond a period of 6 months from the date of submission of such completed application. Stop. In State of in Debabrata Theory Supra, after elaborating, discussing the factual metrics and the policy concerned with the state of West Bengal,
It has been held as follows, para 60. 660. Quote, in fine, the present appeal succeed on 2 counts. First, there is no policy existing to govern compassionate appointment to the post under local authorities in the state of West Bengal, and hence, in absence of such a policy, compassionate appointment cannot be granted. Second, assuming that there was such a policy, it would be of no redeeming purpose to direct that applications for appointment on compassionate grounds be considered and decided several years after they were filed. Stop. In this juncture, this court would like to add that in Malayananda Shetty, the apex court has in no uncertain terms as that when such delay is clearly attributable to the state or the state instrumentalities, that cannot be taken against the person who is seeking the rehabilitation assistance from the state. Stop. In a recent judgment, a division bench of this court has, having appreciated all the aspects of the developing law, including the difference of opinion in certain points, held in Suchitra Ball versus State of Orissa and others, judgment dated 27 June 2023, delivered in WPC number 2081 of 2021. That was observed as follows. Para 78, 79, 80, 81, 82, 83, 84, 85, 86. Stop. Learned counsel for the petitioners and the learned counsel for the appellants as well as the respondent writ petitioner have in unison stated that if the petition filed by the writ petitioners, the respondents in the writ petitioner respondents are considered within the 4 corners of the Orissa Civil Services Rehabilitation Assistance Rules 1990, taking the date of death as the date of consideration, their cases will be covered and they will be entitled to get the rehabilitation assistance appointment, which for arbitrary action of the state has not been so far issued. Stop. It has been also stated by the counsel for the petitioners, the respondent petitioners, that in one case, since the mother is also found eligible.
No, my lord, not eligible, my lord. He is medically unfit. So rule provides any of the family member can take up.
As the mother was alive, is alive, the son who applied for the rehabilitation assistance appointment was denied on that ground that when mother is alive, no other persons can be given the benefit from the family. What is your good name, sir?
B.K. Misro.
Mr. B.K. Misro, Learned Counsel, P.K. Misro, Learned Counsel has pointed out that in
My name was recommended for appointment as a peon, my lord.
Judgment. In earlier, this point came for consideration before a division bench.
My lord,
That was answered that his son can be considered if there is no competing claim.
my lord.
And that has been, the SLP has been dismissed.
Ajit Kumar Barik.
Right, has stated that this court has already decided the said issue in Ajit Kumar Barik versus State of Orissa and others, colon 2018, 2L10.
And upheld by Apex Court in
Stuff. The state that challenged that decision in Ajit Kumar Barik, where the Apex Court had declined to interfere with the proposition is made in that case. Stop. In Ajit Kumar Barik Supra, this court has had occasion to hold yes, under Rule 9(7) of the Orissa Civil Services within bracket Rehabilitation Assistance Rules 1990 refer to a ward who is a minor at the time of death of a government servant. The case of the applicant is not covered under the said provision. In the present case, due to delay and laches on the part of the collector to issue district certificate after 13 years from the date of when the registered Orissa Administrative Tribunal by his letter dated 16/12/2022 forwarded the application for inquiry into the distressed condition of the family as required under Rule 8(1) within bracket small b of the rules. Stop. The appointment letter was issued in favor of the widow of the deceased employee in the year 2016. However, he was not fit to discharge the duties, which was not disputed by the parties. As such, the impugned order is an error apparent on the record. Accordingly, we set aside the impugned order dated 17/11/2017 passed by the Orissa Administrative Tribunal, Court of Bench, Court of in OA number 375 within HC of 2018 and direct the opposite party number 2 to issue appointment order in favor of the petitioner within a period of 2 months from today in court.
Para 7 is my lord.
All right. Law has been discussed in
6 and 7.
No, 6 is a definition clause.
Yes.
The law has been discussed in para 7 of body. So, para 7. Of course, the first preference is to be given wife, husband of the deceased employee, then son and unmarried daughter. However, nowhere it was stated that in the case of a family member in order of preference in the hierarchy is unfit and a medical certificate furnished to that effect, claim shall not be considered for engagement of the other eligible distress condition of the family. Therefore, the finding given by the tribunal in the impugned order that she is not prepared to accept the Group D post and offered it to her son in ignoring the materials on record is not sustainable. So the crux of the said observation is that if there is no conflicting claim, even the family can choose whom they would like to get the benefit under the rehabilitation assistance scheme. Stop. The family members who are eligible in order of preference has been given in the said system rules. Stop.
I'm the only legal heir now.
All right, this having appreciated the submission of the learned counsel for the parties, we find that all these writ appeals can be disposed of in terms of the direction as issued in Suchitra Ball's Sutra. But with some explanation in respect of the certain aspects which are not categorically dealt in Suchitra Ball's Sutra. We direct the appellants to consider the petitioner respondent under the old scheme called Orissa Civil Services Rehabilitation Assistance Rules 1990. When we direct the appellants to consider under the Orissa Civil Service Rehabilitation Assistance Rules 1990, we make it absolutely clear those applications which are totally comes within the parameters of that scheme, those will be considered as the fit applications for purpose of consideration of the rehabilitation assistance scheme. However, on union consideration and on consideration of the distress condition report, state government may issue the appointment letters to the deserving families, but this we leave in absolute discretion of the state government. So for the question relating to the aided government school is concerned, government institutions are concerned, or the block grant institution is concerned, that will be covered by the government policy as framed by the GAPG department.
14/10/19.
14/10/1998. Yes. 14/10/1988 as the
98.
98, yes, 14/10/98 was referred as stop. So for the objection as raised by the learned counsel for the appellants, some of the applications have been filed after the new rule came into force. In this regard, nothing more is required to be explained, and the scheme itself contains a rule of limitation that all such application has to be filed within a period of 1 year from the date of death. As such, if any application filed even after the new rules came into force, but under the applications are to be considered under the old rules, and the application has been filed within the 1 year of from the date of death, all these applications has to be considered as valid. Stop. We further observe that the all such consideration has to be made considering the date of death, not the date of consideration. In this regard, we are consistent and followed the principle as laid down in Malayananda Sethi Sutra. Stop. We direct the appellants to consider the cases of the petitioner respondents within a period of 3 months from today. For that, state shall form a special committee with all concerned.
Some more time.
Already delayed
4 months.
No.
Because it
Not bargain. From today, as the judgment has been pronounced in the open court, and it is within the knowledge of the counsel for the appellant who are the open court in presence of the counsel for the appellant. We make it further clear that this court will not extend the time in future. Therefore, we would advise the state government to form a committee who will decide these matters on work footing Stop. While deciding the matter, as the philosophy behind the policy goes, that the state government should show and demonstrate its benevolence, looking at the family at this place who served the institution for long period. All right?
Applicants to also cooperate.
What cooperation? Their materials are with you. On the committee. Before parting with the records, we direct the council for these respondent petitioners to extend all sort of cooperation with the state so the matter can be resolved in the earliest possible time. Stop. In view of this observation, the interim judgment / order stands modified to that extent. In the result, the appeals are disposed of. No orders is to cost.
I may be pardoned, my lord,
Please consider this. There are certain cases where the other side is not appearing, or in your case, you are the appellant or the respondent. I am the respondent. You are the respondent. I am appealing for the appellant. I didn't state.
I am for the respondent, my lord.
No, she says the somebody municipality is the captain.
No, I am not going to state the respondent.
Which is the case?
My lord may pardon me. In my case,
His name, tell me.
Item 7, item 6.
I may be pardoned, my lord. In a
dismissed. No, I am challenging the
case, my lord.
same question, but I am the applicant here.
It always give this number
51 by 2022.
all right. The 51 just separate.
In that case, relying that judgment of part in W number 367, that order has been passed. So that he says that since
No, always.
Moran on the set cannot be records.
No. What is your good name, sir?
Pardon me, my lord.
That has been recorded. Along with Mr. Prithia and Mr. Muduli, Dayasis Naik for
Lordship may pardon me, my lord.
Just a minute, allow me to complete the order.
Patna, kindly wait.
My lord.
This the judgment in order. So stop the judgment in order accordingly interfered with and the observation and direction is made. I hope would apply in the case of the appellant also.
With the lordship kind permission, item 10. The lordship had already heard the matter was fixed today. The entrepreneurs are not getting the reimbursement fee. I have to take the priority tomorrow, day after tomorrow,
It is not possible.
I will file
the first week of October. I didn't already give a date on 12th of October.
There is already an order. The last case I filed a new case because they have asked me to vacate the hospital premises. Though the Honorable Supreme Court and this Honorable High Court's order is in my favor.
That so they come with the content that you see them. How can you?
No, they have issued it recently only on 14th.
Already taken care. You file an application. The
Already filed the IN.
All right.
Mr. Arun Patnaik, you are moved.
My lord, in my case, writ appeal number 96 of 2022.
Rehabilitation assistance that all.
No, what happened in on the
Serial
11th
number, then, sir, if it is not in the batch, which is the serial number of your case in
serial
the cause
number?
list?
No, it is in the batch. Serial number must be 20th.
Anyway, it is in the batch. So what do you want? You do not, you don't accept
In
the
my
first
case,
just now.
on 11/2/2022, they offered me a job and asked me to select which group D post I should be observed. I am the widow, my lord. Now,
You don't praise your appeal. Don't praise your appeal.
my lord?
You don't praise your appeal there.
No, I am not on the appeal, my lord. The state is in the appeal.
We are the appellants there. So you granted the benefit.
You have already granted the benefit that is his same.
In which case?
Number is same.
In the writ appeal number 96 of 2022. Out of WPC number 17,419 of 2021.
Number 96 of
2022.
Mr.
Page 10, my lord. Page 10.
Has reported this court. The state has extended the benefits under the rehabilitation scheme. Stop. Mr.
And then when the
But
new
Mr.
Patnaik,
Government advocate, page 5 has stated that.
Page 5, 96. The CEO cause list.
You do not have instruction, I'm writing this.
That I must have that instruction 96.
Mention the date. Then you put the date, Mr. Patnaik.
my lord, on 11/2/2020, the DCP armed 7th Battalion asked me to choose the post, my lord.
11/2/2022.
2000, my lord. Before the new rule came into force.
So here is your case, because you are a married daughter, it was withdrawn.
No, my lord, I am the widow.
Then have you an instruction?
Then after 1 month, when the new rule came into force, they asked me to submit another application, my lord.
No appointment has been given.
All right.
So Mr. Patnaik, so your case will also be covered by this order.
Yes, that will be
Covered by my lord's order. Because he says he made an application prior to coming of the new rule. That is a source. He's somehow.
In Annexure 3, my lord, Annexure 4 to my writ petition, they have offered me to
The applicants will not create exert pressure for filing the fresh application.
I made Pradhan to make a mention. Out of the board, one single the director personal appearance of the secretary for tomorrow. Because that read appeal is pending. May I pray your lordship may take up this matter tomorrow.
Always give the list.
At first hour 10:30.
Always on condition that you will be complying this order and not go to the Supreme.
This will be covered by my lord's order. This will be covered by my lord's order.
Item 6. Item 6, sir.
6 covered by 7.
Course 6 also is covered. 6 also including the batch. Solve it is over now. Call item 8.
Item 8.
All right, then the matter will be listed on 12th of October 2023 at the request made for Mr. D.K. Mahapatra, no? D.K. Mahapatra, Learned Council, appearing for the not appeal number.
Item 8.
Oh, appearing for the appellant. Whether there is any representation from the respondent?
Yes, ma'am.
In item 8, who is for the respondent?
You are Mr. Abhijit Patnaik. All right. And others in view of the order passed in such instance will give the date. Over.
Only one. In item 10, the fresh matter filed, I only want the eviction notice to be stayed in view of the order passed by this honorable court. That is a fresh matter.
These can't be,
This can't wait. The honorable Supreme Court has stated that we are allowed to continue. They are now issuing an eviction notice, Your Lordship.
that has to be hard. My law on my
This honorable
friends
court,
mentioned
this year-
that has been listed at the bottom of the list.
That is a fresh matter. Challenging the eviction.
On your mention, it has been listed after notice.
Yes. Nua matter.
On 12th October.
Sabja missing it was directed to be combined
Let it be listed on 12th.
No, it has been, it is not delisted, it is just directed to be listed.
My lord, but they have issued the order of eviction. That is why.
So you file a IA? You file a IA for fresh orders?
That is fresh matter.
You have to mention the IA.
No, already they are on board. The
IA is on record.
Yes,
No, I don't have the record. So he's saying there is a
fresh matter, 30,000 for 5445. The last matter of item 10.
Mr. Rautray, it is much easier if you file an IA and mention the IA because there is no.
Challenging the eviction notice.
Even the fresh matter, you can file an IA and mention it.
On board.
He says that he doesn't have the filer copy. Keep the number.
30,545. Tomorrow, my chat.
Now ready to this.
No, let it come tomorrow. Man.
Milord, please, 1 minute. Milord, my case is adjourned from today, but is not listed. Kindly give me short request to that. I am wrong, but he says that you mentioned it. Okay.